This matter relates to Malot's deputation. In fact, the period of deputation is going to be expired by this month. In fact, there is an interim order and proceedings are completed. My humble prayer for losses, can it be on Monday next month for consideration?
For motion,
No, whether this admission, hearing is completed.
Monday. Okay.
Next, please, Your Lordship. Lordship, I pray for listing of two matters for motion, Lordship, on Saturday.
Tomorrow.
Tomorrow, Lordship.
Your Lordship, item number 13 and 27.
Sorry, Lordship,
Both
may
the
I?
matters are listed for the hearing, but I am still to receive a documentation based on which the argument will be proceeded. So therefore, I will request some time for those documents from the petitioner.
What is this matter about?
The one matter is pertaining to transfer and posting, and another is it means removal from service.
Both are different matters.
Yes, both are different matters, but I will require two important documents, which I have already instructed the petitioner to give me.
We are for the respondent.
No, I am for the petition
Okay,
in
yeah.
both cases.
By item number 13, you need an accommodation.
Yes.
For how long?
After 15,
Okay. You are going to file an additional affidavit.
no, only just one document. I require it for my arguments.
So you can't place that document.
That is only for my reference. Your Lordship.
And what about the 27?
And in item number 27, again, I have to get some instruction because there are list of petitioners. And they have got certain recent developments in that matter.
Item number 27, there is only one petitioner.
No, item number 27, we have, yes, item number 27, I will be requiring one document for my arguments, which is for my own reference. In item number 13, we have list of petitioners.
Then,
For transfer and posting, there recently some new developments has taken
but
place,
item number
which I will require.
13, there is only one petitioner also.
In item number 13, Sushil Kumar, there are 24 petitioners.
Jit. All have been transferred.
No, they are not been transferred. They are we are challenging that transfer and posting. But recently some new development has came.
You have an interim order?
No, we haven't interim order because the matter has been finally been listed for final hearing.
Okay. So you don't have an urgency. Okay. Item number 13, at the request of the counsel appearing on behalf of the petitioner, matter stands adjourned to be listed on 27th of February. Item number 27, at the request of the learned counsel for the petitioner, matter stands adjourned to be listed on 11th of May. Not 11th of May, on 14th of May.
Beyond April, if your lordships.
April days, we don't have so many working days.
Lordship, in item number 8, Your Lordship, I have filed in Lordship affidavit in reply, small reply, Your Lordship.
Item number?
8.
Ah,
This is for final disposal, Your Lordship. This is not
What
in
do you want?
record. This is not in record, Your Lordship. I filed. That affidavit is not in record.
You want to
I
bring it in?
filed. I may be allowed to place in record.
Maybe submission matter, my lord, last decision on 31, my lord, but left over, my lord. Because regarding my lord, petitioner declared unfit in a review medical board, my lord. Review medical examination. One fact is listed but not his, my lord. Maybe next week in the.
Next week data are ready.
Wait, please, Lordship, I beg to mention for listing of a writ petition, Lordship. The
For-
writ petition, it's a
for-
non-payment of salary matter
For
for motion, Lordship. Lordship.
Okay, so item number 22 and 23, Your Lordship. Lordship, in both the matters, the counsel, Mr. A. Thermo, is unable to appear. I think he had to leave for Dibrugarh last night.
Who? Who?
Mr. A. Thermo, Your Lordship. In 2017, item number 22, he's a petitioner. And in the.
A Somua. Okay. You want an accommodation?
Yes, for the date.
Okay. At the request of the learned counsel for the petitioner in WPC number 2323/2023 and respondent number 4 in WPC number 6343/2023. The matter stands adjourned to be listed again on 2nd of June 2026. Next.
That's it. In item number 15, my lord, response number 3 file affidavit on 2nd February. So I need 1 time, my lord, to give response to that. There is no question, my lord. Response
You are for the petitioner?
number-
You are for the petitioner?
Yes, my lord.
You have any interim order?
No.
At the request of the learned counsel for the petitioner, matters stand adjourned to be listed again on 28th of May 2026. Liberty given to the petitioner to file reply to the affidavit in opposition filed
Response number 3.
by the respondent number 3.
To mention 2 items for listing for admissions.
Okay. 25th of February.
And one for reference in the mediation.
Possible to refer?
May not be possible, my lord. May not be possible. Petitioner is the first wife of the deceased, my lord. And there is a second wife also, under Hindu law, my lord. In the mediation, maybe may not be possible.
Where the petitioner is the first wife. Then
But the respondent number, my lord, in my lord, obtained an earlier and another certificate, he also got some benefit, my lord. But there is a order of the district commissioner, my lord, saying that petitioner is the first wife and directed the psychologist to issue NOK certificate, my lord. Fresh NOK certificate. Accordingly, I applied again, my lord, but the certificate was not issued to me, my lord. Till date, my lord. Speaking order kindly see, my lord, case 52, my lord. After hearing both the parties.
age,
Case 52, my lord, 52, my lord.
now what do you want? You are
First, I want to family mention, my lord.
family pension. You are the second wife. You are the second wife. Admittedly. First wife is dead or alive? First wife is dead or alive?
Alive. Alive. Alive, Lordship. Yes.
Matter ends. What is there? Send it to any mediation or not. He's entitled to. There is no concept of a second wife in Hindu. Are you Hindu?
Yes,
Are you Hindu? Hindu people
yes, ma'am.
by religion? Hindu. Then your husband is Hindu.
Yes.
Matter of what? What are you challenging?
Not giving the NOK certificate, my authority was, my lord, issue a letter, my lord, saying that NOK certificate is required, my lord. But that NOK certificate is not issued by the my lord authority. There is a speaking order by the district commissioner, the NOC by 52, my lord. Thereafter also not issued the NOK certificate, my lord. Because of non issuing the NOK certificate, petitioner is not getting the, my lord.
So what this order of 3/9/2024 says that you should be issued the NOK certificate.
Yes,
Then
that's not,
who?
that's right, my lord, thereafter by case 53, my lord.
Who have not issued?
Happened with the, my lord.
What is wrong with the circle officer? Why you are not issuing
Lordship,
it?
so for my instruction, Lordship,
Huh?
the report, the report that the Srimati Asalata Adhikari, the wife, it means the petitioner, Lordship, and Safila Adhikari, daughter, are the legal heir of the deceased Kamal Country Adhikari, and second wife Srimati Junaki Adhikari, along with her two children, namely Opurbojiti Adhikari and Banti Adhikari, residents at Nalbari, have been submitted to the Deputy Commissioner, Dhubri, Bhait, so and so, letter dated so and so. It means
2/12? What is the date?
that regarding the application, Lordship. Application date, Lordship, it is received on 7/10/2024, Lordship.
No. You speaking order passed by the subdivisional magistrate. It's clear that he is the first wife.
Page 52.
There's no
Yes,
quarrel
yes,
with
no-
the
no
fact
quarrel,
that he is
no
the
quarrel,
first wife.
No
Then
quarrel.
why you are not issuing the certificate?
That, Lordship, it will deduction.
And when did this person die? Your husband? Huh?
5/5/2014.
And 5/5/2014, the family pension has not been finalized.
Yes.
What is wrong with your department? My goodness. The circle officer should be paying the interest. No. I think we should pass that order.
So can you see the?
No, because of you, he has not got the pension.
Lordship.
So the entire pension amount which he is entitled to will be disbursed by the whoever it is, and an interest thereupon would be paid by the state and shall be recovered from the circle officer. Then only things will move.
His Lordship, after perusal of the aforementioned.
No, I don't understand what is this perusal, not perusal of
It is-
all
it
these
is the-
things.
the
A simple thing.
order of
And,
the
and
district-
because of these matters being sent to mediation, these matters are getting delayed.
Yeah, Lordship,
Should have been finished on
there
that
is-
day itself.
there is an order of the district judge, London District Judge Dhuburi dated 27/7/2022. After hearing both the parties, the undersigned have come to the conclusion that the next kin certificate in respect of Kamala Country Adhikari may be issued in favor of the Asalata Adhikari.
Who is he?
Petitioner.
Then also you
No,
are
no,
not
it
doing
is
it.
speaking order, Lordship, that was given by the subdivision officer. Lordship.
So therefore,
No.
after doing this also, why you are not picking up
No, that was, Lordship. Can you
15
see the-
days?
see my
15 days.
instruction?
No.
No, can you see my?
You
instruction?
want the next of kin certificate. Okay.
Yes.
You want the next of kin certificate.
Yes.
Pension is also there. Well, you do one thing. We pass an interim order now, asking them to provide the next of kin certificate within 15 days
Sure, sir.
to you and get the matter again listed. Then we ask them to finalize the pension on the basis thereof.
Lordship.
Okay? Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. J.K. Goswami appears on behalf of the respondent numbers
Lordship, 137, 8 and 9.
137,
8 and 9.
8 and 9.
Photo key.
Mr.
Lordship, 4 also. 4.
R.K. Talukdar appears on behalf of the respondent number 5.
Lordship, 4 also.
Appears for respondent number 5 and 6. You appear, R.K. Talukdar, 5. And Mr. A. Solia appears for respondent number 2 and 6. And Mr. So-and-so appears for the respondent number 10. Isn't it? Okay.
Lordship, I will appear 4 also, Lordship.
Okay, 4 also. The present petition has been filed by the petitioner being aggrieved by the non-issuance of the next of kin certificate by the respondent number 9 and the resultant delay in finalization of the family pension to which the petitioner is entitled to upon the death of the petitioner's husband on 5/5/2014. Full stop. The materials on record show that on account of the husband of the petitioner marrying the responding number 10, during the subsistence of the marriage of with the petitioner, there is there a dispute is sought to be created as regards the issuance of the next of kin certificate in favor of the petitioner. Full stop. However, the said dispute had already been set at rest by the order dated 3/9/2024 passed by the respondent number 8. Full stop. It is under such circumstances, this court finds no justification on the part of the respondent number 9 to issue the next of kin certificate, including the name of the petitioner, her son. You have a son? Son or daughter? Daughter, as well as the children
The second wife.
born out of the wedlock of the husband of the petitioner with the respondent number 10. Full stop.
Two.
Because he is entitled to on the base the children on base.
Two children. sir.
Therefore, I didn't put child.
Lordship. Child.
REN has been put therefore that to the regard.
Lordship.
Yeah. This is entitled because of section 16 of the Hindu Succession Act. Full stop. Taking into account the above, comma, this court directs the respondent number 9 to provide the next of kin certificate to Mr. J.K. Goswami, the learned counsel who represents the respondent, the learned senior, additional senior government,
Lordship. Additional senior government.
who represents the respondent number 9 in the instant proceedings. And the said next of kin certificate be placed before this court on the next date, that is on 2nd of March 2026. Full stop. On the next date, this court shall, on the basis of the next of kin certificate, pass appropriate directions for the finalization of the pension, family pension. Simple thing. A copy of this order be furnished to Mr. J.K. Goswami, the learned additional senior government advocate for due compliance.
Lordship. Lordship.
Yes, what is your case?
We are selected for promotion to the.
To be nationally appointed to the Indian Forest Service with consequential retirement and pension benefit.
So we agree.
Then your name was inserted in the year 2020. Where?
Page 15, my lord.
Page?
15 in Excel 1, my lord. In
Page
serial number
15.
2 and serial.
Let
number
us
7,
see,
my
let us see. In exercise of the provisions of the Iman, appointment of a union of commission has approved the select list for promotion from the state services of Iman to the Indian Forest Service from the select list 2000 containing the names of following officers towards filling up of the promotion quota vacancies available in the Iman. Then, what is your name?
Number 2, my lord.
Samir Boydya.
Serial
Your
number
name
7,
is
my lord.
there. Then
Then, my lord.
you retired in
Excel 2, my lord.
2024. From under submission of declaration and certificate of Iman, it refers to have the honor to send here with the necessary declaration in respect of the following state Iman recommended for promotion of the so and so. Oh, your name is not there.
Yes, my lord. So I agree, my lord.
Your name has been kept out.
I am selected, my lord. We are selected, my lord, but the state government not forwarded.
But by that time you have retired.
Yes.
That is the reason why. So you say because of the delay, but when did you retire?
The petitioner number 1 is retired on 30/06/2024, my lord.
Huh?
30 06/2024, my lord.
So as on 31st of December 2024, which is page 15, you have already retired.
Yes, my lord.
What case?
I entitled to national promotion.
National promotion, how?
National appointment.
No, the year, this is an order being passed in the year for the select list of 2020. This is the exercise being carried out on that. How do you get the national promotion? You are selected only. This is a select list published,
Yes,
isn't
sir.
it?
I am selected for the.
He
year
was under
2020,
zone of
my lord.
So what? You have selection is different and being appointed is different.
Yes, my lord.
You have a right to be considered. They have considered, but the order was passed late.
In my, in support of my case, my lord.
Where's your select list of 2020?
This is the, my lord.
So therefore, the select list came only in 2024. So how do you get the benefit? Show me a judgment by which I can help you out.
The Alexa, 6, my lord.
Alexa 6.
6, my lord.
Yes.
Page 25, my lord.
In exercise of the powers under Emmanuel, pleased to notionally appoint with immediate effect the following 5 officers of the state here to the Indian Railway Services on the basis of inclusion of their names on 96, 97, 2009 meant by the Iman in matters of so and so and to allocate them in the Rajasthan cadre of so and so. Okay. So this was done by them.
Yes, my lord.
Where is the union a party? Yes, what is your stand? Is it permissible?
Awaiting instruction, Lordship, in this case. Lord.
This is a promotion. But my question is,
Huh?
this is a
1744.
the main problem arises because of you. You have issued it late.
Lordship, I'm awaiting instruction, Lordship, in this case.
And did you comply with this thing? What is required?
Yes, my lord.
It is informed of the above and further requested to forward necessary for promotion of the along with the food ministry. So did you do this? Page 15. Copy to the chief secretary and all you did this. Where is it? You submitted this.
Yes, my lord.
Now, what do you say about number 5? At page 16, Roman 5. Isn't that a condition?
Yes, sir.
So, how did you give this? How can they give this? There is a certificate that is in services on it.
Selected for 2020.
No. Therefore, if you are applying to this particular document at Annexure 6, we are to look into the select list. Where is the select list for this? Because at that point of time, these people may have been in service. Then
That instruction,
what instruction? Matter finished. It's a Thursday matter. Thursday matter has to be finished. Don't you think, Mr. Roy? It shouldn't go beyond today. Then how do I give you? No. You see, unless you challenge 31st of December 2024 and more particularly clause 5, isn't it? Because this document cannot be forwarded in your case, taking into account that you retired on 36, 2024. You are not in service. Have you challenged this order of 31st December? What? No, you have not challenged. Then
We are selected by this order, my lord.
understood, but there is a clause 5 which says that he is in service. But he is not, you are not in service. Huh? Mr. Counsel, the clause, you are basing your case on this order. And this order categorically says that you have to be in service. For
At point of time, we are in service, my lord.
understood. On 31st of December, you were not in service. Then how can they forward your name? Unless you challenge that clause 5. How will they forward? And then obviously you can't get the benefit. That's your instruction.
I will take instruction, my lord. I will take instruction.
You don't take the instruction, you need to challenge clause 5. You have to withdraw and file a fresh one challenging clause 5. And that can only be permissible if they have done similar things earlier in terms with Annexure 6. Why this clause was mentioned? Because your right to promotion arose on such and such date for compliance with certain things. So therefore, in that select list proceedings, this was done in a particular manner. So you have to improve your case in this manner. What you are asking that on the basis of the select list, you should be given a notional promotion. You cannot get it because the select list also says that you have to be in service.
One day maybe accommodate, my lord.
What? Matter over? What? I close it with a liberty to you to challenge this order, clause 5, if you want. Otherwise, you can't help it. You don't have a case. Or you want to withdraw, just withdraw with liberty to file a fresh, then I don't need to mention all these things. We close it.
Okay, maybe.
No. Close it. No, Mr. Counsel, the problem is this. This person has already retired. So therefore, the question is, you need to act fast. In the matter, in this way, you cannot get any relief. You want to get a relief for your client, you have to do it properly. Not on the basis of that. You have to show what? First, that as per this particular provision by which a person can be recommended as an IFS, this is a particular regulation where there will be a select list. And on the basis of the select list, you would be chosen. If you are chosen, you are entitled to. Irrespective of the fact that this has happened late, in fact, there are circumstances where they have permitted. So therefore, this clause 5 cannot sustain.
I think was forwarded for selection, my lord. At that time, maybe I was in a service, my lord.
So therefore, unless clause 5 is not interfered with by this court, can you get the benefit? My question is that. Yes, that is what I am saying. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, Mr. I. Bhattakur appears on behalf of the respondents and on behalf of the State Forest Department, as well as Mr. So-and-so appears on behalf of the Union of India. The grievance of the petitioner herein, how many petitioners are here? And the other is also retired.
Yes, madam.
Oh, so yeah. The grievance of the petitioners herein is that the petitioners have not been granted the benefit of the order dated 31/12/2024 of being recommended of being promoted to the Indian Forest Service for the select list 2020. The learned counsel appearing on behalf of the petitioner submitted that such benefits, though the petitioners have retired as on the date on which the order dated 31/12/2024 was passed. But the respondent, but the government in the Ministry of Environment and Forest and Climate have granted benefits of such recommendation and for promotion even post the retirement by giving notional promotion, and in that regard had referred to clause annexure 6 to the writ petition. This court have duly taken note of the order dated 31/12/2024, which no doubt recommends, which no doubt approves the select list for promotion from the State Forest Service of Assam and Meghalaya joint cadre to the Indian Forest Service to both the petitioners. But it includes a clause, Roman 5, in the said order, which stipulates that a certificate has to be given that the person, that the officers are in service as on date. It further appears that in view of the said stipulation, the respondents in the Forest Department could not forward the names of the petitioners, and resultantly the petitioners have not been granted the benefit. Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, submits that the petitioner would like to withdraw the instant writ petition with the liberty to refile, challenging seeking similar reliefs, including challenging clause 5 of Roman 5 contained in the order dated 31/12/2024. So taking into account the above, the instant writ petition therefore stands closed on withdrawal. Liberty, however, is given to the petitioner to again refile, claiming the similar benefits as have been sought for in the instant writ petition, provided there is a challenge to clause Roman 5 of the order dated 31/12/2024. Yes, madam. What is this? What are you asking for?
Your Lordship, the repetition of one that belongs to God, the repetition,
Hmm.
the widow of one that belongs to God, who died in harness in 1997,
1994.
died in harness in 1997. The first one,
First one is 97.
97.
Which one? Meera Rani Gwala.
Yes,
Lodge.
2730, no?
So 1997. Then what happened?
Thereafter, being the widow, she proceeded for pensionary benefits. That was denied to her. She approached before the Honorable CAT and then to this Honorable High Court also. But both the Honorable Tribunal and the court has stated that Lakiram Gwala is not a screen employee, so he is not entitled for the pensionary benefits. This is the fact. And somehow.
Wait. You applied to CAT
Yes,
in the case of, in both the cases.
both case. No. First
Okay,
one.
Srimati Meera Rani Gwala. So you applied to CAT. The CAT Okay,
Dismiss.
2017,
7.
7. Okay, then what happened? What happened in CAT?
Is that as the Latvian Board is not a screened employee, screen means it's a procedure. After screening, actually, the employees got the permanent status.
Okay, so he's not a screened employee, so you are not entitled to pension. Now thereupon you move the High Court in the division bench. What did the division bench say?
Say,
Say.
say.
Now what are you asking here?
Petitioner accepted the situation as the rule is rule. But what happened in 2016, she got some information that another person named Raj Narayan Jadhav, in the same position, same story, his wife got the pensionary benefit, and what the department did, they proceed for post facto screening. After the death of that employee, they have proceeded for post facto screening and thereby managed to give the pensionary benefits to his wife.
But
And this is
madam, tell me why should I entertain this type of repetition?
If the rule is like that, Your Honor,
If the rule is that, then don't you think CAT is the best person?
the information got, the petitioner got the information in 2016. She made an inquiry, then came to know that this is fact. Then she approached before the
Before the
Industrial tribunal.
industrial tribunal. Process is still going on.
industrial tribunal.
Yes.
It's a reference. You moved under 2A. Now you moved under 2A.
Raised a dispute there, Lordship.
Ah,
Conciliation 2A. Conciliation failed. Against this order, they have to come here, Lordship.
No,
As
not
per-
that- not that. Actually, conciliation failed. The process is, when the conciliation failed, the assistant laboratory is to forward the report to the respondent number 1 here. And the respondent 1, after receiving the report, the respondent 1 is to forward the same to the industrial tribunal. This is the procedure. But
Is it? How?
if I am wrong,
No, I don't think so. If the conciliation fails, the matter has to be referred to the government, appropriate government. What do you mean? The respond number 1, thereupon what is he required to do? You'll make a reference. If it doesn't make a reference, then what is to be done? You are challenging not granting, not issuance of making a reference.
it is delayed.
By 21 years.
Filed the reference after 22 years of delay.
Where is that order?
Page 26.
Page?
26. Last page.
Which matter?
In first matter, Lordship.
I have a page 2730, page
Yes, Your
25. Government of
4322.
India, ID between the management of Iman and the Rail Mazdoor Union over denial of family pension and consequential benefits to Meera Gwala, widow of so and so. And raised the dispute against the management of IA over denial of family pension and consequential benefits to so and so. After a lapse of more than 21 years without giving a justifiable reason for a delay. In this connection, the judgment of the Supreme Court in so-and-so has ruled that a dispute should be raised within a reasonable time. The dispute is therefore unfit for reference to CGIT and hereby declined. So you are challenging the 6?
Yes.
Okay. So the question is whether it is an industrial dispute or not.
Lordship, it is an industrial dispute, but CGIT is rightly, it was claimed after 21 years, Lordship. In terms of that
But
Supreme
the
Court.
fact that the petitioner have been fighting before CAT
Lordship. It was
and
in
then after CAT, the
2007,
petitioner came to the High Court
Lordship.
and where the High Court held that the petitioner was not entitled to family pension.
Pension.
Now, on the ground that somebody else had been granted, the petitioner raised another dispute in the year 2018. And it was given in the year 2016.
Yes. It still came to know, but
But don't you think, madam, you having accepted the judgment
Yes.
of
Okay.
no, accepted the judgment of the learned division bench. Do you have a case for an industrial dispute on the ground that some illegality or right or wrong has happened in the after 10 years?
Your lordship, because I am layman. I don't know what is the thing of being a, I'm saying about on behalf of petitioner. Petitioner is a layman. He don't know what are the rules and regulations, but when she came to know the similarly situated person also.
No, maybe. So after 10 years, you may know something which you have already accepted the fact that, okay, you have taken a service, you didn't challenge it before the High Court, Supreme Court. And then thereafter, after 10 years, something happens and say that, okay, now you also give me this family pension because you have given it to somebody else. Can that be an industrial dispute? And I have serious doubts as to whether it would be at all be an industrial dispute. And we are playing for whom? Who has asked for reference?
Union,
And why the union is not here?
but
The
petition.
moment union is not there, you come under 2A. Who can ask for a dispute? Either you may ask for a dispute, which you have never asked for. The union on your behalf asks for a dispute,
Yes.
for a reference under section 10, isn't it? So therefore, how you can come before this court,
But I realized that.
but you don't come again under 2A, taking into account the 2A is only in respect to termination, discharge, or anything to do with termination, discharge, or anything. So therefore, taking into account the judgment of Rajasthan State Transport Corporation, you can go under 2A also. That is why my initial thinking was a 2A, whether you can go. You go under 2A. It has to be an industrial dispute. Industrial dispute is sought to be ventilated by the association or the union, and the union has stopped thereafter, have accepted. Matter has to end.
Take all my part, we have to make a, the union should file this exhibition, I may be allowed claimant. My need to her. So,
That is one, but more particularly, how do you accept it? That means the union is now raising a dispute in the year 2018. After you have your husband have expired in the year 1997. Then well, isn't it? Can there be a dispute? You see that not only that judgment, also see the Salima Payne's judgment. Why should this court interfere? What do you say, Mr. Roy?
Lordship. Lordship, actually, yes, your lordship.
Because main problem, madam, the main problem you have is you have accepted the judgment.
except it doesn't mean I have just submitted it, but no.
Because what is happening is there might be many changes. Just for example, I'm telling you,
Under misconception.
I'm just telling you, I'm here who sits out here and takes up matters pertaining to compassionate appointment, and I dismiss it right, left, and center. For me, any compassionate appointment after 10 or 11 years, that should not have been even directed for consideration. Even in a motion, I don't do it. Tomorrow, in the next roster, which will happen after 6 months, another judge who comes in and is very considerate on that, and he passes an order that you consider and give it to him. This judge, pursuant to that, they consider it. Now, can you come over and say, then look here,
Once.
whatever may be, you again consider my case. Problem lies because in 2006-7, you have accepted the final outcome that you are not entitled to. Yes, maybe later on they may have given it, but there has to a closer to a dispute, and it has come to a close. Maybe wrong. The cat or even the learned division bench must have been wrong. But it has come to a close. The dispute has come to a close with that. Forget about other things. So then how do you have a dispute now? Yes, Mr. Roy.
Lordship,
Should I only keep on making your submissions?
Lordship,
Isn't that your submission?
Lordship.
I understood the scenario, Your Lordship. Actually, sometimes this type of.
I have given you,
happens, Your Lordship.
madam, I have all what you call sympathy for you. But law is different. The dispute has come to an end. It has reached a quietus in the year 2007.
Section, letter
Yes,
of
there might have
uniform-
been, they must have now given it to somebody, but you can't reopen a thing which has closed. There is already an adjudication that a person who has not been screened would not be entitled, would not be considered to be a employee. And accordingly, the question of family pension is not to be given. This is a thing which has happened then. Yes, tomorrow there may be an office memorandum after 10 years, but would that really give you a right for raising a dispute? Difficult. I think the division bench may understand your and be more sympathetic. Sympathy is very difficult.
Entertained. my
It's all, it's,
thing that was processed and the only their plea is that it is, we came there late. Only this was maybe rest, maybe right.
no, it is not the claim that you are late. Madam, you have to understand, it is not a delayed claim. A delayed claim leads that there is no industrial dispute. The government says now that where is the industrial dispute? Maybe for some other reason. You see the judgments of Salima Paints. The Supreme Court have said that a period of 7 years is too long a period for an industrial dispute to remain.
I may be allowed to speak like that. In annexure 6, page 26.
Page,
Page 26.
we have page 25 in Mira Rani Gwala.
Page 20, annexure,
Annexure 6. Yes.
in last paragraph. Rail Mazdoor Union Guwahati by representation data so raised the dispute against the management of NF Railway Maligaon over denial of family pension and consequential benefits to Srimati Meera Gwala, wife of late Rathuram Gwala, ex-monarch, who expired on 1997 after a lapse of more than 20 years without giving any justifiable reason for the delay. In this connection, the judgment of Honorable Supreme Court in the case of has ruled that a dispute should be raised within a reasonable time. The dispute is therefore unfit for reference to CDIT and is hereby declined. That reasonable time, Your Lordship, this is the main point. Reasonable time, Your Lordship, my knowledge should be there. That there is something happening like this. When I got that information, there is something happening like maybe rules has been changed, maybe whatever it may be, maybe rules were there also, but I was deprived of my claim. Maybe.
So, madam, wouldn't you come within the direct example of a classic example of a fence sitter? What were you doing from 2007 when the division bench said you are not entitled to? Now tell me, after the division bench holds it, where is that they have given it to somebody else?
That page,
Not next 2016.
Section 1 and 2.
Page number.
So this person has been absorbed retrospectively. So
Post facto is the.
first you have to be absorbed. First, your husband has to be absorbed retrospectively prior to 1997. Then only it can happen.
After his day, actually, by processing the post facto paper screening, your
Hmm.
lordship.
So where is your case? Is it your case that he should be absorbed retrospectively?
In a my case is your lordship.
You see, the matter even went to Supreme Court also. Kindly see page 18. Now, what is your claim? You don't have a claim that you want a family pension. How can a family pension be given unless this person is absorbed retrospectively? And a bad case. I think dismissed.
Not sure.
Don't ask your client to have further agony of a matter being pending. Chalo. And what is about the other? Same.
But she has not approached to any court right now.
Then,
She has not approached to any court right now.
so after 94, you,
Continue to process the department only.
uh,
Communications continue.
for the 94, you have done this. So what you did is you took along with him, took along with this petitioner, Meera Rani Gwala, you brought her also to get more strength. Huh? Because this person died in 1994
4,
and you started to initiate the industrial dispute when?
18.
Proceedings for paper screening of Raj Narayan Yadav X so and so. This one, yeah, it for Yadav so and so. State Bank of India, Raj Narayan Yadav. Okay. Chalo. Heard Ms. D. Chaudhary, the learned counsel, appearing on behalf of the petitioner in both the writ petitions. Mr. S. S. Roy appears on behalf of the respondent
All the-
number, all the respondents. Both the writ petitions have been filed challenging the orders issued by the Ministry of Labor, Government of India, whereby it was opined that the that the question for making a reference to the Central Government Industrial Tribunal does not arise in view of the fact that both the petitioners have approached after considerable lapse of time. Full stop. This court finds it very pertinent. No, full stop. Next. Though there is similarity in the issue involved in both the writ petition, but for a better understanding, this court finds it relevant to take note of the brief facts in both the case. WBC number 2730/2025. The materials on record, the pleadings in the present writ petition reveal that the petitioner's husband, one Luturam Goala, LUTU, bracket since deceased, was initially appointed as a casual laborer in the construction organization of the NF Railway Maligaon, and later on attained the temporary status on 30/2/1986. The said late Luturam Gwala expired on 19/3/1997 in harness as an unscreened railway staff, and at the time of his death, he was serving as a motor driver. The petitioner, upon his death, received the service gratuity and retirement gratuity as applicable for an unscreened staff of the railways. Be that as it may, the petitioner on several occasions visited the office of the General Manager Construction, NF Railway, for sanction of the family pension and other settlement dues. But the authority of the General Manager, bracket P, oblique Construction, NF Railway, as well as the FA and CAO, NF Railway, rejected the claim for sanction of family pension owing to the reason that late Luturam Gwala had not been screened, and as such, they have paid her only the service gratuity. The petitioner, being aggrieved, approached the learned Central Administrative Tribunal, Guwahati, by filing an application which was registered and numbered as OA number 98/2007. The learned Central Administrative Tribunal rejected her petition, stating that the petitioner's husband being unscreened, the petitioner was not entitled for the benefits of family pension, etc. Full stop. The petitioner thereupon challenged the said order passed by the learned Central Administrative Tribunal in OA number 98/2007, which was registered and numbered as WPC number 2209/2008. The learned division bench of this court dismissed the said application. The petitioner, being aggrieved, further approached the Supreme Court by filing a special leave petition, which was numbered as SLP number CC 16872/2012. But the Supreme Court, by the order dated 1/10/2012, dismissed the said special leave application. Full stop. The petitioner thereupon accepted the fate that the petitioner would not be entitled to family pension. Thereupon, the petitioner came to learn that another employee, wife, another employee who was in temporary status upon his death was granted family pension in the year 2016. The petitioner, upon coming to learn about the same, submitted a complaint to the Assistant Labour Commissioner Central a communication dated 8/6/2018, dated 8/6/2018, stating that the petitioner also is entitled to the family pension as was granted to the wife of late Raj Narayan Yadav. Full stop. Now, the petitioner submitted a complaint in the year 2018, 18 billion, date to Nidigo. The said representations were submitted. Submitted a complaint. Date in the year 2018. To the Assistant Labour Commissioner will delegate. In the year 2018. Before the Assistant Labour Commissioner Central, stating inter alia that the petitioner herein is entitled to the family pension inasmuch as the wife of late Rajnarayan Yadav was also granted family pension. Upon inquiry being made by the Office of the Assistant Labour Commissioner Central, a communication was issued by the SPO/Construction IMLG for the General Manager Construction NF Railway to the Assistant Labour Commissioner Central, stating as to why the petitioner was not entitled to the benefit of the family pension. In the said communication, it was categorically mentioned about the fact that the petitioner had approached the Central Administrative Tribunal and then seeking family pension, which was rejected. And thereupon, this court, the learned division bench of this court and the Supreme Court, wherein also the petitioner's plea was rejected. The record further reveals that on the basis of the said communication, the Rail Mazdoor Union NF Zone, Guwahati, submitted a communication to the Regional Labour Commissioner Central Guwahati stating that an industrial dispute had arisen and for resolution of the same in terms with the provisions of the Industrial Disputes Act 1947. The Regional Labour Commissioner thereupon submitted a report to the Secretary Government of India Ministry of Labour and Employment by the communication dated 6/1/2022. And thereupon, the impugned communication was issued dated 4/3/2022, whereby the requests were made by the Rail Mazdoor Union NF Zone, Guwahati, seeking a reference to the Guwahati Industrial Tribunal, CGIT, Central Guwahati,
Central government.
Central Government Industrial Tribunal was rejected on the ground that that the industrial dispute was sought to be raised after 21 years without giving any justifiable reason for the delay. Full stop. এখন WPC 2 full stop. WPC number 2662/2025. The instant writ petition was also filed, has been filed by the petitioner claiming that her husband, late one Kitish Gwala, Khitish Gwala, since deceased, joined the respondent railway as were casual labor and later on attained the temporary status on 16/3/1985. It is a further case that late Kitish Gwala expired on 14/6/1994. Full stop. The petitioner thereupon did not take any steps. The petitioner thereupon received the service gratuity as well as the retirement gratuity as applicable for an unscreened staff of the railways. The petitioner kept quiet thereupon, and in the year 2016, the petitioner came to learn that the respondent railways have given family pension and other benefits to the beneficiary of a staff who had expired in harness without screening, which raised a fresh cause of action. Full stop. The petitioner thereupon submitted a complaint which was responded by the Divisional Personnel Officer, NF Railway. stating inter alia that as the husband of the petitioner was an ex-unscreened casual laborer through though got temporary status on 16/3/1985, but he died on 14/6/1994. Hence, as on 30/4/1996, he was not on roll. And under such circumstances, there was no reason for conducting post facto screening for late Kitty Squala, ex-unscreened casual laborer, for granting family pension to Srimati Gayatri Gwala, widow of the deceased unscreened casual laborer, as was done in the case of Raj Narayan Yadav. The Rail Mazdoor Union NF Zone, Guwahati, raised the dispute which was rejected by the impugned order dated 4/3/2022 on the ground that the said dispute was sought to be raised after 24 years without giving any justifiable reasons for the delay. In the backdrop of the above facts, under such circumstances, the petitioner approached this court. Both the petitioners approached the court, challenging the impugned orders by which the Government of India, Ministry of Labour, have refused to make a reference to the Central Government Industrial Tribunal. The question arises in the instant case as to whether the petitioner in WPC number 2730/2025 can maintain the instant with petition, taking into account the question arises as to whether the petitioner in WPC number 2730/2025 can maintain the instant with petition, challenging the order dated 4/3/2022, impugned in the said writ petition. The issue as to whether the petitioner was entitled to family pension have already been decided, have already been negated by the learned Central Administrative Tribunal, by the which has been confirmed by this court, by the learned division bench of this court, as well as by the Supreme Court, as far back as in the year 2012. The petitioner thereupon accepted everything, and in the year 2018 sought to raise an industrial dispute through the Rail Mazdoor Union NF Zone. The issue as regards the petitioner in WPC number 2730/2025, having already reached a quietus, as there is already an adjudication that the petitioner is not entitled to the family pension, irrespective of the fact that the petitioner have delayed after a long period, is also cannot be reopened by way of an industrial dispute, as the same have already been settled by the learned Central Administrative Tribunal, which have been confirmed by the learned division bench of this court, as well as the High Court, as well as by the Supreme Court. Under such circumstances, the question of interference with the order dated, communication dated 4/3/2022, insofar as rejecting the request for a reference to the Central Government Industrial Tribunal by the Rail Mazdoor Union NF zone does not arise. Fusto. Now coming to the facts of the writ petitioner in WPC number 2662/2025, it is seen that in the year 1994, the husband of the said petitioner had expired. The petitioner received all service benefits, or received the statutory service gratuity and retirement gratuity as applicable for an unscreened staff of the railways. The petitioner never raised the dispute till 2018. Fusto. The silence of the petitioner all this while not everybody. Fusto. Under such circumstances, the petitioner, in the opinion of this court, cannot seek to raise an industrial dispute which has already died its own death on account of the silence of the petitioner for the last 21 years, 24 years. First, in that view of the matter, this court does not find any ground for interfering with the order dated, the communication dated 4/3/2022, by which the Ministry of Labour of the Government of India have refused to make a reference to the Central Government Industrial Tribunal. Accordingly, this court therefore does not find merit in both the writ petitions, for which the writ petition stands dismissed. Madam, let me dismiss second one. That Kuala 1994, let me dismiss it. But take the document of Kuala, the second one, and withdraw the writ petition and move cat. On the ground that what they have done is this: your husband died in the year 1997. Okay. This Rajna and Kuala, because I can't open it here. Forget about IT. You take up this issue now. That look here, this has happened in the year 1996. There was a move for, have you seen, you have actually not applied it properly in both the cases. If you see the case of the second one, which doesn't have a case, at that point of time, 56,000 employees were regularized from casual. See the reply which has been given in the second case. 56,000 were regularized. And what they say, that look here, let Kritish Gwala expired in the year 1994. But in the year 1996, that is 1996, we have regularized these people, but we left out this Rajendra Narayan Gwala
Raj
Yadav.
Narayan.
And therefore he was given the benefit. Now your person, the second one, the first one, have died in the year
97.
1997. And therefore, why he can't be granted the benefit?
Yes, I got the point.
Now move cat for that. Because of this, you withdraw the first and the second I dismiss it. Okay? I think better off. Because seeing this document, I think you have a case there. Because he has been given benefit later on,
After
in 2018, 16.
16.
If in 2016 this benefit can be given, why not to you? Okay?
I'm very much obliged for this, Rajesh Davash. Very much.
Because you have not actually applied facts properly in both the cases. You have a case in that. Okay, in the first one, it was আগৰ যে cases হৈছে. The learned counsel appearing on behalf of the petitioner submits that though the petitioner had assailed the order dated 4/3/2022, by which the request for raising an industrial dispute by the Rail Mazdoor Union have been rejected. But the petitioner herein would not like to pursue the instant writ petition. The learned counsel for the petitioner further submits. Second writ petition, second. That the petitioner's husband expired. First condibo. On
On road.
1997 in harness as an unscreened railway staff. Full stop. The petitioner was not granted the benefit of the family pension on the ground that the petitioner's husband was an unscreened staff of the railways. However, in the meantime, it has come to the notice of the petitioner that the railway board had issued a circular on 3/9/1996, whereby casual labor on this roll as on 30/4/1996 were regularized whereby 56,000 casual laborers were regularized. The learned counsel appearing on behalf of the petitioners further submitted that the husband of the petitioner ought to have also been regularized at that relevant point of time. But the same was not done so. On the other hand, a person, namely Raj Narayan Yadav, who was also a casual laborer in the construction organization, was also not regularized in pursuance to the Railway Board's order as on 30/4/1996. Oh, madam, there is one problem. You have a case, but the 7/11 was the 97 was the date. But in the meantime, you expired. This person was post facto screening as on 7/11/97.
Your Lordship, actually the on roll, that date was 30/4/96. And my client died in 97.
No. That is 97, it's okay. But the screening, this Raj Yadav was missed out, you see,
Missed out the screening process.
on 7/11/97. And he was alive then.
Alive and-
When did he die? This Raj Yadav? It will be here somewhere.
7.
He died on 20 November 2007.
Seven.
Anyways, I'll give you this liberty. I'm formulating it for you so that you can drop a petition if you want to.
Lordship, if my client is on roll as on the date 30/4/1996, then.
So
maybe
therefore,
try-
that is why you can do it. Huh? Yeah, kile rasta. But have been regularized. His services were regularized.
Was sick at the time.
The learned counsel appearing on behalf of the petitioner submits that an employee, namely late Raj Narayan Yadav, who was also similarly situated like the petitioner's husband, was on roll on 30/4/1996 and was not screened in 1996/97. But in the year 2015, the respondents in the railway department have retrospectively deemed that the said Raj Narayan Yadav was screened on 7/11/1997 and thereby absorbed late Raj Narayan Yadav against against the post retrospectively. The learned counsel therefore submitted that the petitioner therefore would be well advised to again approach the Central Administrative Tribunal, taking into account that this aspect came into light only after the judgment has been passed by the came into light in the year 2018. The Learned Council further submitted. Therefore, that the petitioner therefore would like to withdraw the instant petition. Because taking into account the above, the petition therefore, the instance writ petition therefore stands closed on withdrawal. Full stop. The withdrawal of the instant writ petition, however, shall not preclude the petitioner to approach the learned Central Administrative Tribunal, Guwahati, if so advised.
Okay.
So I formulated your point, so you put it in that. Yes. But the second one goes, because this one, I saw that document here only.
That was there.
Where is Mr. S.S. Roy? And Mr. Gogoi also called him also, that lady also. Yes, what is this?
I'm declared, I'm first wife of the deceased husband. And I am deprived of my pension. The other, the respondent is his third wife.
First wife.
I am first wife, and respondent is third wife, she is getting the pension at present. On the basis of a succession certificate. Now that succession certificate, that has been set aside by the by 70-80 managers. The lordship can see judgment at page 54 annex of claim. Earlier, I filed it, then their petition was, I have to withdraw, only because of that it was not filed against the succession certificate issued in favor of the respondent. Then I filed the 70-18 that the judgment is no longer.
No. Have you complied with this order passed on 1/9/2025? Amended cost title filed. And who is the third wife?
Third wife is respondent number 5.
So why haven't you made the third wife a party?
Because she is getting the pension money.
So obviously she has to be made a party. Can we pass an order without
Yes,
hearing her?
she is party money.
Where?
Rupali
Rupoli Bagre. Who is paying for the third wife? Have you filed your affidavit? Then what do you want to do?
We refer to mediation there.
No, mediation, can this matter be sent on mediation? Is it possible to send it on mediation? No. Mediation has to be on the agreement of both the parties. Mediation can't happen. You file your affidavit. Mr. B.P. Bora, appearing on behalf of the respondent number 5, submits that he would like to file an affidavit in opposition. It is also seen that the other respondents have also not filed an affidavit in opposition. List this matter again on 4th of May 2026. In the meantime, such affidavit be filed on or before 23rd of April 2026 by all the respondents. Liberty given to the petitioner to file any reply on or before 2nd of May 2026. Mr. Roy, I give her the liberty to move this court, not
Lordship.
that. Because she has a case.
Lordship.
So therefore, I give her the liberty to move this court on these facts. You are there?
No, no, Lordship, that matter
Huh?
is item, next item she is.
Okay. Okay, we have, she let her come.
Yeah.
Because she has a liberty, she can move. And more particularly, another very important aspect is pension is a continuing right. Maybe that order is right. 43/2022 is right. There's no quarrel with that. But pension being a continuing right, this court can very well look into that aspect. But here she has only challenged 43/2022, and I cannot help her with that. She has to withdraw and file a revision. Madam, you do one thing. I give you the liberty to move this court. You don't need to go to CAT. You move this court. That order, and on the basis of which I have formulated the matter, you make a writ petition in that regard. By bringing in that document wherein there is a decision pertaining to making these regularizing those 56,000, which includes you. Okay? And move this court. Yes, what is this?
Lordship, here, Lordship, I have not received the instruction. I pray for some time, Lordship. Disability pension.
Matter pertains to
Disability pension.
disability. This cannot go for mediation
This cannot go, my lord, because he,
because you have to set aside an order. How can,
Yes,
it
yes.
cannot happen like.
Lordship.
It has been submitted that the instant writ petition cannot be sent for mediation. Mr. S.S. Roy, appearing on behalf of the respondent, submits that he has yet to receive the instructions taking into account the above. Their notice has also not been issued.
Notice issued, Lordship. Issued, Lordship.
No. Huh?
8/8. 8/8/25 now.
No, notice has not been issued. Notice has been dispensed with. Have you
As-
seen the order of 8/8?
No, Lordship.
Have a look at it. You may be knowing better. Have to issue notice. Will let us issue notice on this matter. Issue notice making it returnable on 6th of May 2026. Mr. S.F. Roy, who represents the respondent numbers 1, 2, and 3, accepts notice. An extra copy of the writ petition be served upon him by tomorrow. The grievance of the petitioner herein is that the petitioner herein have assailed the order dated 25/11/2024. Whereby the petitioner's claim for disability pension was rejected, as well as for invalid pension. The respondents are directed to bring on record their stand by filing the affidavit. On or before 23rd of April 2026, liberty given to the petitioner to submit reply on or before the next date.
Obliged.
Addition item 7. May I please, Your Lordship?
Hmm.
Lordship, the petitioner hearing is an Assam Rifle partner. And he is working in Assam Rifle. He is claiming the pedigree of the rank and pay because he belongs to the engineering cadre. And similar relief was granted to the other cadres. There are several engineering cadres in Assam Rifles. Technical cadres, sorry. And he is working as an electrical signal cadre. What happened in this case?
What is the stand of the respondent?
It took a stand that others, though other have been given the benefit, this is not applicable to EFS. That is their stand.
To ESI.
EFS, electrical fitter signals.
Where is that? Why haven't you filed a reply? Why haven't you filed a reply?
Lordship, what happened? I have lost contact with the client because he was working in Assam Rifle. After COVID, I could not get his number, and he is also not contacting me. So I could not get his signature to file the reply. I can file one written arguments so that the entire things can be.
Written argument has to be based upon the instructions.
Yes, Lordship.
But if these are the statements which are there in the affidavit, can you overcome it on the basis of?
Because those things have already been verified by the Honorable Supreme Court and different judgments of the High Court. There they have stated that these engineering, there was a disparity in the technical cadres, Assam Rifles and other CPOs, Central Police Organization. So that rank, it is the rank of warrant officer and the scale of warrant officer. That is equivalent to ASI in other Central Police Organizations. All other cadres except electrical fitter its signal, others have already been granted. That is Annexure 3 is the list of the technical cadres.
Wait. Let me understand what is the facts then. That he joined Assam Rifles in the year as on Iman as a rifleman.
Yes, Lordship.
After joining Assam Rifles as rifleman, he had undergone technical training for electrical fitter signal and Iman in the year 86-87. Completed in 87. Thereafter, he was remastered as rifleman with effect from rifleman general duty. As a result of remaster, became a technical cadre of the Assam Rifles, that is cadre electrical fitter signal. That he has undergone upgradation of EFS class training in the year 90 and EFS class A in the year 91 has successfully completed. Subsequently, Avida was promoted to Lance Naik with effect from switch. Yes, explain the case.
There are different
You are Habildar ESI.
EFS,
Yeah.
electrical fitter signal. There are other
Electrical
technical
feeders,
cadres
EFF.
who are entitled to the rank of, that is, Lordship may kindly turn to and page Annexure 3, page 21.
Yes.
This is a communication which stated about the cadres who are entitled to the rank of warrant officers. The granting of warrant officer rank to technical grade in equivalence with the BSF to include the following trades: Havildar radio mechanic, Havildar cipher,
You
Havildar
are now AE.
Lordship, I'm an AE. All others
Havildar
have-
Electrical, so it is granting of warrant officer rank.
Yes, Lordship.
to
Then
take.
initially, this Havildar radio mechanic, they have approached the Meghalaya High Court. And ultimately, it went up to the Supreme Court in the case of Union of India versus KK Dinesan.
Wait,
There-
who had approached?
This
Havildar?
One of the Havildar radio mechanic.
Radio mechanics, okay. They went to the Supreme Court.
Supreme Court and that was upheld. Thereafter, the other technical, that is, I have annexed the judgment, that is the Union of India versus KK, Dinesan KK, it is at annexure 4. Here, the operative portion is at page 34. In our considered opinion, in view of the absence of
Wait.
any- last
In-
4 lines.
In view of the total absence of any plea on the part of the radio mechanics in other parliamentary have by performing different or more onerous duties as compared to radio in Assam Rifles. Impugn decision of the government are clearly irrational. So Havildar radio mechanics now is brought with
They became warrant officers.
with
They were
warrant.
granted the pay scale of warrant officer. Then subsequently, the other cadres, that is operator radio line, that is, they have approached the operator radio line was there. Havildar. That is AC. In the annexure 3, Havildar operator radio.
I
line.
did some matter with Havildar Cipher. Cipher,
They have also got.
they got it from Meghalaya, no?
Yes, Lord.
They went to Supreme Court.
They probably.
They were given by Meghalaya High Court.
Yes.
Cipher.
Then this Havildar radio operator radio line, they were given by the Kerala High Court of Kerala, because one of the person who after retirement he went to Kerala and he has given that I have annexed at page 35 annexure 5. This Sasi Kumar AG.
Okay. The benefit of the judgment and hence redesignated with replacement of scale in the scale of so and so. All of them had retired from service. They are entitled to get their retirement benefits refixed on the basis of the pay fixed on such upgradation along with the areas of pensionary benefits. Seeking the benefit of judgment, petitioners have also approached the secretary in the light of the declaration. The second respondent shall consider reply of each of the petition and grant them benefit on the basis of upgrading, restructuring, replacing of the scale of pay of the post for which they retired by recognition of the Iman. They have been granted Iman along with Iman and Iman in all relative within a period of 4 months. The attitude of the respondent in comparing the year like the petition to exclusive when the issue is one relating to rank and scale of pay with regard to the parameter that too, which have been implemented by the along the state issue of the sustainable benefit of the judgment to the person's life, living way they live. Now, this was a case pertaining to the relief sought for in the Union is seriously opposed by the residents who are on the ground, have already retired. No, what is the case out here? So page 21 is not in respect to Assam Rifles.
Lordship. Page 21.
Hmm?
It is free. Some right.
How do you know?
It is written by the DD RS Dhulla, Colonel DD Administration for DG Assam Rifles.
So all these, as per this document of 1998,
Yes, Lord.
they have already been put as warrant officer.
Yes, except electrical fitter signal. Others have got, because this case is pending, because others have approached that different courts at different point of
No,
time.
no, I am not on that. This, by this document of 1998, granting a warrant officer to technical grade in equivalence with BSF to include the following trades. It includes the Havildar electrical fitter signal.
Yes.
So the electrical fitter signal is to be given the warrant officer rank as per this document.
Implemented. That is why the KK Nation has approached the court and it is went up to the Supreme Court. So they raised the question of disparity regarding their qualifications. Then that was decided, and thereafter, once the KK Nation was decided, thereafter the operator radio lines, ciphers, others have approached different courts and they got the relief. Our case is pending here, so that is why we have not been given till now. Because I am the only electrical fitter signal who has approached the court.
So this is the Shillong bench.
Yes, Lordship, there are other.
Shillong bench matter pertains to this one, wherein according to rank of central organization area constables.
Because this disparity was between the different CPOs. Because Assam Rifles was initially given the army analogy. So their ranks were named differently. That is why this disparity has come.
There is no dispute with the qualification, duties and responsibility of the person holding identical or ranks, but treated differently merely because they belong to different departments or basis for classification.
If CPC recommendation was done there, that was not implemented. That is why. Right.
But these ciphers, I passed an order here,
There is a cipher judgment, it is by the Shillong bench itself.
but I have also passed an order on cipher.
This is the earlier judgment.
No, understood, but I have also passed an order. I think this has been then went to the division bench of justice. Thank you and all. Because Bibhas Pathak was appearing in that matter a long time. This happened in 2021, 22 earlier.
Here in short, entire thing is being.
Let's see the denation order. Yeah, all very long judgments written everywhere.
Judgment is there.
And what is this order passed by the division bench of this court? In
That
which
is
case?
also relating to ORL. That is
Huh?
operator radio line. One judgment passed by this honorable court was challenged before the division bench.
Directed to the, this is for?
This is for operator radio line, ORL.
Let's see the Dinesh's judgment. Where is it reported? Not this Supreme today.
I have annexed it.
No. Get me the Supreme Court. Where is the Econ Direction 2008 1 SCC 586? Give me that. Judge. Not this. Yes, Mr. Gogoi, what do you say?
See, regarding radio mechanic, radio operator,
Everybody got it.
CIPAR, there is no dispute. This is as per the Home Ministry's guideline, office memorandum, Lordship. In respect of Lordship, other cadre, it is not Lordship.
No, what do you say about page 21?
Page 20 and page 21 is a letter issued by the Lordship, the one Lordship, Colonel to the Lordship, Ministry of Home. It was never Lordship, it was applied Lordship. It was never Lordship that came into effect Lordship. It is there just he has Lordship mentioned that the following categories are equivalent to BSF Lordship. That part is not applicable here Lordship. Here Lordship, the radio mechanic, CIPAR and radio line operator, there is no dispute Lordship. When Lordship
No,
said
no,
pass
no,
order-
the union had disputed a lot and they fought and then got.
No, Lordship, no, even the, as per the
Wait.
documents, there is no dispute, Lordship. They are already as per the ministry, Home Ministry's guideline, Lordship. Even KK Dinesh also as per the Home Ministry's guideline and other court, other judgment which is annexed here also as per the Home Ministry's guideline, Lordship. They are entitled, Lordship. But Lordship, here in this case, Lordship, the petitioner belongs to Lordship,
Electrical fitter signal.
electrical fitter signal. He is not entitled, Lordship.
Why?
Lordship, his qualifications and other parts is not, entry point is defined, Lordship. Qualification part is defined, entry point is defined, Lordship, and rule is defined in the other categories, Lordship. Other is CPF, Lordship. He's not equivalent that category, Lordship. Initially, he was joined as a constable, Lordship. Then he himself opted to source that fitter signal category, cadre, Lordship. He given the undertaking, Lordship. After that, Lordship, we have sent him to the Lordship advanced training, technical training. And that particular post is a promotional post, Lordship. But that particular post, Lordship, after obtaining the higher grade, Lordship, technical qualification, they will entitle, Lordship. Otherwise, Lordship, the radio mechanics and other, they have, before they have obtained the post, Lordship, they have to obtain the qualification, Lordship.
Then also you gave him an opportunity to take this benefit and you have given him at the post of Havildar EPS, EFS. Then what
Havildar,
is wrong?
Lordship, their initial entries, Lordship, different. Even Lordship, when they are appointed in the Lordship, Havildar electrical fitter signal, the qualification is totally different,
No, you brought him,
Lordship.
you appear for Assam Rifles also.
Yeah, I'm representing Assam Rifles, Lordship.
So when you are up, it is your Assam Rifles also contention that they should be brought as a warrant officer.
No, Lordship, we have filed affidavit, Lordship.
No, this
we-
is the
we-
document by issued by
Document
DG
issued
Assam
by
Rifles.
one officer cannot be treated as a document issued by the Ministry of Home, Lordship. We are governed by the Ministry of Homes, Lordship.
Lordship,
Mm.
then taken by
Lordship.
the-
So
Lordship.
therefore, Assam Rifles stand
Lordship.
cannot be equated with the Ministry of Home.
Lordship, Ministry,
How do you take care of Annexure 3? Let
Annex-
us see in your affidavit.
Annexure T, I have replied in paragraph 13, Lordship. Paragraph 13, Lordship. Our affidavit, Lordship.
Ministry of Iman. Only redesignated the post of Iman, radio man.
It's a Lordship, reply of the paragraph 15 of the repetition, Lordship.
Of Iman. The case was taken up by the Iman seeking clarification whether the above order is applicable to Havildar so and so, so and so, so and so. Only or other trees also. The ministry clarified that the rifles can redesignate HCRM as foreign officer. If pre-revised and revised scales of so and so are identical to the pay scales of Iman in the Iman. The ministry has not granted approval to the redesignate Havildar so and so as warrant officer. No, you say out here, let's see page 21 again, read it.
Lordship.
Reference to so and so, subpara 1 of 14 of English but sheet forwarded by the letter with so and so. of granting of warrant officer rank to technical grade A trade in equivalence with PSF to include the following trades. Please acknowledge. Then
The stand of the ministry was there.
so that was a proposal submit.
Lordship.
Page 21 is a proposal
Yes, sir.
submit.
There.
Then what is the reply sent by the ministry on 13/3/1998?
13/3/1998.
Where is the
Only
document?
radio mechanical part.
Where is the document?
That document probably, Lordship, it is not here, Lordship.
Havildar radio mechanic, Havildar draftman and Havildar parking assistant only other trades also. The ministry letter number clarified that the right designated Havildar warrant officer as warrant pre skills assessor, Assam Rifles identical to the radio mechanic in BSF and CRPF. So that is where the issue started. Because they have categorically stated that the Havildar personal assistant, that Havildar draftman and this ORL other who were not entitled to according to them. So they approached the court and thereafter everybody has come. Because court has said that you cannot make this disparity. That was challenged. Because this, I have shown the judgments that cipher or this ORL operator radio line, those were not included here.
No, I find a reference out there. to
Lordship,
the-
in Lordship,
No,
paragraph.
there's a finding a reference out there in the Kerala High Court judgment. Kindly come to this paragraph at page 37. Paragraph 4.
Yes,
Yes, read it. So
There
small,
will be
nobody can
series of
see.
correspondence between the Director General of Assam Rifles and Ministry of Home Affairs in respect of the disparity faced by those Assam Rifles. Finally, on February 1998, Ministry of Home Affairs has recommended redesignation of radio mechanics and head constable in Assam Rifles as warrant officers with replacement pay scale of 4,000-6,000 in order to bring them to them on par with their counterpart in the central forces. Based on the recommendation, Ministry of Home Affairs by letter number dated 3/3/1998 informed the Assam Rifles that
This is the letter of 3/3/98. he's
Lordship,
referring.
that letter, Lordship.
Inform the Assam Rifles that they could
redesignate the head constable radio mechanic as warrant officers provided WPC number such and such. Their pre-revised and revised pay scales are identical to the pay of the counterparts in CRPF and BSF. Lordship, this is
further.
but the redesignation could not be carried out since there was a disparity between the pay scale of the radio mechanics in Assam Rifles and their counterparts in CRPF and BSF. In the meanwhile, as per the order dated 10/10/1997 passed by the Ministry of Home Affairs, it was notified that the President was pleased to rationalize the rank structure and pay scale of the non-gazetted cadres of the Central Police Organization. And as a result of this exercise, certain ranks were to be marked. The rank structure was communicated in the order along with the revised pay scale and replacement pay scale. Copy of this order was sent to all the paramilitary forces, including Assam Rifles. Thereafter, by office of memorandum dated 22/1/1998, the Government of India, Ministry of Home Affairs, it was clarified that the order dated 10/10/97 was equally applicable to all the advertised category. Later, also contained direction to WPC number redesignate of the three.
No, actually, the problem is when you take out a printout in India Kanun, these are where the cases are. You leave out these and then come to redesignation.
Yes, Lordship.
The officer provided their pre-revised scale. So therefore you have to leave because you are taking out a printout in this manner. Very difficult.
Redesignated.
You are not helping the cause.
Designation of the three posts, including head constable, radio mechanic as ASI in central paramilitary forces. The respective replacement pay scales were also ordered. Nevertheless, the restructuring or redesignation did not materialized in Assam Rifles and the disparity continued. The Director General of Assam Rifles therefore submitted a report on 24/4/2001 to the government regarding the progress on the P. Anamoli cases, in which it is stated that the technical persons were placed in the rank of Havildar in Assam Rifles, whereas their counterparts in Central Paramilitary Forces were in rank of ASI, Ministry of Home Affairs. Ministry of Home Affairs had ordered to submit a proposal in directing the cadre comparison in BSF, where the rank of ASI is available in other technical and along with the financial implications. The proposal along with the financial implication was submitted to the Ministry of Home Affairs, and the case was lying in the Ministry of Finance for approval. However, there was no positive action. One of the radio mechanic issued a notice of demand to the Ministry of Home Affairs and the Director General of Assam Rifles, inter alia praying for giving the effect of the office memorandum dated 10/10/97 and office memorandum dated 22/1/1998. Thereupon, the Ministry of Home Affairs by its order dated 26/12/2000 informed the Director General of Assam Rifles that his proposal has been examined in consultation with the Ministry of Finance, and it was found that there was no point of comparison of the grades and scale of the pay for such posts across various central police forces. It was further stated that the proposed upgradation may disturb the relative of various grades within the Assam Rifles, and there was no functional justification for upgradation of all these posts. At this stage, the radio mechanics approached the High Court of Guwahati by WPC number 497/2001. That is the denisons. Then
So
thereafter,
therefore you have the Justice H. Borua's order.
no, Lordship, denison was.
Because at that point of time, we had same
Yes,
court, no?
it was same.
No, same court. These coming from Meghalaya was also same, Tripura was also same.
Yes.
497 is where?
That regarding 497, I'll take it out because I don't have this judgment.
This. Now therefore tell me what has happened.
497.
497 is there, page 42. Mr. Counsel, you are not prepared. See the number. WPC number 497. Do you see that? On top? Yeah. Then now come. In the counter affidavit filed therein, it was stated Assam Rifles personnel were in receipt of pay and allowances on army analogy with various groups of so and so. Conform to the functional qualitative requirements of these groups which have varying pay scale. It was further stated that on the recommendation of the Fourth Pay Commission, with effect from so and so, the police force has been granted pay and allowance entirely on the lines of central pay scale. And further, Mr. Counsel, how can one read it? This is half stitched out. Very difficult.
Here also his lordship belongs to the radio mechanic.
Huh?
Here also page 42 also persons belongs to the radio mechanics.
Maybe.
Lordship.
It's not a question of radio mechanics and all.
Yes.
Now, these documents which are there, the government of the central government rejected it.
Lordship.
There's no quarrel with the fact that you rejected for everybody.
No lordship.
Yes.
No rejected. Lordship means for that purpose, lordship may kindly 338/2020 that part is there, radio mechanic lordship.
Where?
That
No. Kindly come to page 37.
37 lordship.
You see, that is why the proposal along with financial implication was submitted to the MHA
Lordship.
and the case was lining with the Ministry of Finance for approval. However, as there was no positive action, one of the radio mechanics issued a demand notice
Lordship.
to the Ministry of Home Affairs and the Director General of Assam Police, inter alia praying that for giving effect to the office order dated 10/10/97 and the office memorandum dated so and so,
Lordship.
Thereupon, the Ministry of Home Affairs, by this order dated so and so, informed the Director of General that his proposal has been examined in consultation with the Bureau, and it was found that there was no point for comparison of the grades and scale of pay for such posts across various so and so. It was further stated that the proposed upgradation may disturb relatives of various trades and grades within Assam Rifles, and there was no functional justification for upgrading this post. At this stage, the radio approached the court. So, therefore, it has also always been the stand of the respondent, central government, that there is no disparity, they cannot be given the pay parity.
Lordship.
One thing, and with other central police organizations. One, and secondly, these warrant officers, there were various requests, all these things have been turned down. Now, what has happened? In the meantime, radio mechanics came over,
Lordship. Even Lordship may kindly,
cipher came over,
page 19 Lordship,
Page?
page 19 for the cipher, page 19 Lordship,
19.
19 Lordship, 19. This is a decision taken by the Union in 1998 Lordship.
In the context of certain
Paragraph
towns being
two,
so and so Iman, is hereby clarified that the orders are equally applicable to all combustion Iman. For example, H. Havildar RF. RF is
Rifleman.
rifle will be given the replacement pay scale of so and so as approved by the government in the said Iman. In the case of Havildar RM,
Radio mechanic Lordship.
Havildar so and so, since pay commission has given the replacement pay scale of so and so in respect of these three categories in CPF, these three categories may be redesignated as ASI in the scale of Iman.
They are already redesignated Lordship.
Yeah, to so and so
ASI is
as
the
Iman.
equivalent post of the
But
warrant.
this is not for Assam Rifles.
Lordship, it is for all
Assam Rifles.
CPME.
Okay.
Then Lordship,
So
that
therefore, he sought for, this is what the radio mechanic, but this was not however granted.
he is not radio mechanic Lordship.
No, no.
So Lordship, radio,
Understood,
Yes.
understood. But here what has happened? You see, what was the demand of the radio mechanic then? So he said, kindly give effect to the office memorandum dated 22-1. Kindly page C36.
Lordship.
You are referring to 22-198. So here at page 37, why this repetition 497 was filed?
37, yes, because this particular particular opinion issued by the central government was not implemented by the Assam Rifles. That is the reason, Lordship. Even Lordship, ASI is the equivalent rank of warrant officer, Lordship. It is redesignated as the ASI, Lordship. ASI is the equivalent rank of warrant officer in the Assam Rifle. They are already getting as part of Lordship officer memorandum dated.
Let us see the Dination KK
Lordship.
judgment. Now we have it better. What is the case?
Dination is the radio mechanic, Lordship.
Huh?
Radio mechanic, Lordship. Yes.
Whatever it may be. Director General of Assam Rifles arises. No, no, it is. Dination is not railway, Assam Rifles.
Assam Rifle is a radio mechanic, Lordship.
That is 497.
Lordship. He is a radio
By the
mechanic.
impugn order, while allowing the reparation, directions have been issued that the permission granted by the Union of India by letter dated so and so to redesignate the post of Havildar as a warrant officer as recommended by the ministry shall be carried out and pay scale as initial, the number of so and so. Let us see how the so and so. The equality of pay scale has been considered, explained and indicated. Initially, pay scale of the amount so and so. In SBI versus yet again in so and so. Tested on the above turnstood board lines and not cast iron imperative, we are of the opinion that in a present case on the pleadings and materials on record support the High Court was justified in issuing the year. Passed by the Ministry of Heaven in paragraph number 7. It was notified that the President was pleased to rationalize the rank structure and pay scale of non-gazetted cadre in Iman, and as a result of that, exercise certain ranks were to be merged and rank structures were communicated in disorder along with the revised pay scale and replacement. It was also centered including Assam. On Iman, an office memorandum was issued by way of a clarification. It was clarified that the order dated Iman was equally applicable to all advertised categories. In the said letter, Direction was also regard to the redesignation of 3 posts, including HM, Head Constable, RM as ASI in Central Valley along with so and so. It appears that the disparity in rank and pay in various Central Valley employees will not be resolved, and on demand, the Director General submitted a report to IA with regard to the progress on demand. Para 4 of the said letter is regard. Rank and pay of the technical cadre RM, Swam Pharma and compounder IA with the intake for the amount are given. For Havildar, rank of Havildar wherein there are, whereas their counterparts in CPU are given ASI. MHA has got ordered to submit proposal in directing cadre to coordinate with BSF, where rank of ASI is available in other technical and also along with financial applications. The proposal along with the financial has been submitted to an area. We will pursue an area for the organization of this object. And the office will be dated. To the meet the stabilities of various grades, the sub-reference and the functional adjustment. And the domination of And how much were you getting, Mr. Council, as Havildar, EPF or what it may be?
Lordship EFS. In as a Havildar,
You are in which scale?
in the pay scale of head constable. Lordship, I am getting 3,200. That I have stated in
3,200, that's 4,900.
Yes, Lord.
Whereas CRPF so and so were drawing pay scale of 1,200, 1315 and 2,000 per month, whose
That-
replacement scale in
Is
the fifth area was 4,000 to 6,000. Okay, now tell me, you have a corresponding ESF or EPF or what is this? In the other paramilitaries for here? Mr. Gogoi,
Lordship,
you have the corresponding EPF or what is this?
EFS.
EFS? EFS in the other paramilitary,
Lordship. Before the Lordship, the paragraph 33, page 33, Lordship, gone,
page
page 33 of the judgment, Lordship,
33.
33. Page 33, paragraph 18, Lordship. Here the decision, the findings of the Honorable Supreme Court in favor of the dead KK Dinesan is dead, Lordship. Yes, because he was already the Lordship radio mechanic having.
No, I've read it. I'm not on that.
Lost.
My question is,
Lost.
whether do you have a designation of
That part I have given, Lordship, in our affidavit. Lordship.
electrical feeder signal?
Lordship, in our affidavit, Lordship, we have given, Lordship.
Secondly, are all these Havildars, radio mechanics, cipher, operators, store signal and all these things, were getting the same pay scale as per the Fourth Pay Commission?
Lordship.
3,200 to 4,900. You're 3,200 to 4,900. Are these
Yeah,
all
in
getting
our
the same
affidavit-
scale?
In our affidavit, page 7, Lordship. Page 7, Lordship. In our affidavit, Lordship.
Pay scale is on page 7.
Paragraph, it's a part of paragraph 11, chart is there, Lordship.
Where?
Page 7, Lordship. Internal page 7, Lordship.
Ah,
I am not running page, Lordship.
okay. Subedar Major, Subedar Nayak, so and so, warrant officer, 4,000 Iman, Havildar. All Havildars are same.
Same, Lordship, same.
So therefore, all these people were getting the same.
Same.
So now my question is, if that be so, have you stated that these electrical feeder signal,
Lordship.
what is the corresponding their duties or anything? Have you said that the
We-
duties are different from
we have-
that of
We have in
what
paragraph,
the Havildar EFS of the Assam Rifles?
we have paragraph 12, Lordship, we have stated, Lordship. Yes, because radio mechanics and other part, Lordship, as per the, my lord, may again kindly come to Lordship, page 19, Lordship.
Feeder signal and
Page
is
19
enrolled as
Lordship.
head constable with higher education as per the matriculation insurance. So it is someone who is regularly enrolled with able objectively. And after enrollment, they are provided additional qualification of different municipal government. During this interpretation is also giving full pay and we have very good municipal. And qualification of the student. So, the duties of trade are not identical in history. The contention of the position is that in this way the civil bank of India. Because this is simply get promoted to the next time. It's how.
Regarding fourth pay commission part, paragraph 8, Lordship.
Yeah.
Paragraph 8, Lordship. Paragraph 8,
Mr. Counsel, I think you need to file a reply.
Lordship,
You
before,
see, the main problem why I'm saying is kindly come to paragraph 27 of the judgment in dissent and Dinesan.
Yes, sir.
Without this reply, you see, Thus, the short questions requiring a consideration is whether, having admitted in the affidavit referred to above the apparent disparity and anomaly in the pay scales of radio mechanics, the administrative authorities, the petitioner herein could be permitted to perpetuate apparent discriminatory differentiation in the pay scale because of the disparity in the pre-revised and revised scale of personnel of the Assam Rifles prior to the recommendation of so and so, irrespective of the identity of their powers, duties, and responsibilities with other paramilitary force. In are considered, in view of the total absence of any plea on the part of the Union of India that radio mechanics in other paramilitary were performing different or more onerous duties as compared to radio mechanics in Assam Rifles, the impugned decision. Don't you think that a reply is required?
Lordship, I know that I could not find. I'll try.
Otherwise,
You know
also,
Because this is a inspect which
Yes,
we
because
have to do.
if-
Because this is the basis on which I can help you out only in this regard. Although I have a thing that, okay, if they are getting the same scale of pay and all, you are an EPS. The fact that he is saying that you could have been a matriculate. And there needs something, a higher qualification to be an EFS to that fact. But the fact that now if you are performing the same duties,
Yes, sir.
then you shall be entitled to the benefit in view of the Dineshon's judgment. We
Then-
can bring you under
I'll-
that.
after donation also, Lordship, not only in the case of paramilitary forces, other judgment is there, Lordship, 22 judgment is also there. Not only, Lordship, equivalence of work, Lordship, educational qualifications, hours and everything, Supreme Court has described, Lordship. That part is there.
No, other judgments we won't look.
Otherwise also, Lordship, paragraph 14, page 14, Milan, may kindly press my affidavit, page 14, Lordship. Where NSG and Assam Rifles are, Lordship, left out, page 14, Lordship.
Of your
National
affidavit.
Security Guard and Assam Rifles is left out, Lordship. Adoption of new nomenclature of Central Armed Police Forces, Lordship.
Page 14.
Page 14 of my running page is not there, Lordship. Internal page 14, my affidavit. Office memorandum is
Adoption
there,
of new
one.
law of Central Iman,
Lordship.
22 March.
One,
The
declaration
terms
of
like
good-
so and so, so and so,
Yes, yes,
etc. have
that
been
was
entered
Mandala contact with of-
by
taken
referring
from
to
the-
the central which are armed forces here in the event. This creates an incorrect reception amongst the each and event. The matter has been considered in the Ministry of Women and it has been decided to adopt the union of the central movement while referring to quotas so and so. So Assam Rifles is not there.
Assam Rifles and National Security Guard, NSG was left out. Lordship. NSG and Assam Rifles totally left out, Lordship.
Why?
This is the policy decision of the government. Today I cannot say, Lordship.
But do they not fall under the CPO?
They have fall under CPO, Lordship.
But they have been left out.
They have
And
been
the
left,
disparity has happened
They-
because of this 2011 decision,
Lordship. Not only that, Lordship.
isn't it?
Not only that, Lordship.
I have very kind sympathy for you, but the fact that you need to come up with a better,
Lordship, I will come up with affidavit
Hmm.
detailing all these.
better.
Second is our own.
If you don't come up, it becomes difficult. Otherwise,
Can it be part had so that after 15 days or 20 days time may be granted, or so that I can try in between?
one type of case which I don't like is this scale of pay. And these are very unnecessarily very complicated.
Otherwise, Lordship, the other parts, other three category getting as because of the ministry's letter, Lordship. That radio mechanic, radio operator, cipher,
Whether the cipher is brought in by the government, no.
no, cipher is there, Lordship.
Where?
Cipher,
Radio operator,
radio operator,
radio operator, that is one,
Eh,
another category is there.
another category is there, another.
Operator radio line. They
Oper-
were not there in that.
They were not there.
Because
No,
of
they
that
have been
is-
given, so therefore
is-
he is also to be, you just find out, in respect, make a chart, or you make a chart if you can't file an affidavit. You make a chart and give it to me. And see as to what are the works and duties of the Havildar is given in those Assam Rifle rules and all, and find it out with them.
Lordship,
If you can't file an affidavit, so that we can look into it.
yes,
Secondly, this letter which Mr. Gogoi has referred to are certain letters wherein there is a reference to radio mechanics and another person, another profession of their occupation. So these are there, but there are others also who have been given benefit by the various courts. In fact, as regards cipher, I have given the benefit out there that, yeah, because that was a very specific thing which was put out there. I think you asked Vibhas Pathak, I have passed an order on that aspect as regard the cipher thing. Following the judgment of the Meghalaya High Court.
Cipher lordship as per TT 1998, cipher and radio mechanic. TT 1998 lordship, central government has decided. TT 1998, SB Dev, after that they are entitled lordship.
No, anyways,
That's
you will find out, so that you can bring yourself within the nation's judgment.
Yes, Lord.
The nation says that these are things. All others remains were going on together. All because the proposal which was given for warrant officer was made as per page 21 for everybody. So therefore, the employer, we may say, consider all to be same with warrant officer and had therefore forwarded it to the Ministry of Home. The Ministry of Home have not considered anybody. And that resulted in filing of the writ petition 497/2001 for radio mechanics. Now you are another one who has come for the AFS.
Yeah.
So therefore, there are cases for cipher, there's cases for other trades and all which have come in. So just find out as to how it is and show me with some chart if you can't file an affidavit. Okay. This matter, and don't expect this court to read those judgments in this manner. Either get some other citations, not this supreme business. One I have got it out here, the SCC online. You get it properly, not this thing. And I'm not going to follow that 2019-18 SCC. Okay. Mr. So-and-so, who appears on behalf of the petitioner, submits that the petitioner, he has not been able to contact the petitioner for filing an affidavit in opposition. Affidavit in reply to the affidavit in opposition. Be that as it may, he would try his best to contact the petitioner so that an affidavit in reply could be filed. Full stop. He submits that in the circumstance the petitioner could not be contacted, he would file a written argument in this regard, and thereby also wherein indicating the similarity of the duties performed by the Havildar EFS with that of the ASI EFS in the other paramilitary forces of the Havildar EFS in the Assam Rifles with that of the Havildar ASI EFS in the other paramilitary forces. List this matter again on 17th of March 2026. The affidavit in reply be filed, or the affidavit in reply or the written arguments be filed before the court on or before 12th of March 2026 by providing an advance copy to Mr. K. Gogoi, the learned CGC.
Boss.
Other matters, I may not have it today, taking into account that I'm having a division bench.
Item number 8, your lordship. It come for final disposal, item number 8. But if it hard to matter, can be, if it's not possible for today. can
What
we
matter
bring
is that? What is the matter about?
Matter is for thanks, your lordship, in the last occasion, your lordship.
Oh, some affidavit. What is the matter about?
What your lordship, 17 years I have worked as a fixed pay.
Huh?
Fixed pay basis, and 17 years on regular basis. So my pension has not been provided your lordship.
Oh, Faisal Rugby.
So it's
Okay. Hmm.
regular basis 17 years, 9 months, your lordship I have worked.
So you are You are entitled to at best proportional pension if Faisal Rugby does not apply. You have filed a reply. Chalo, we have it when? Let's try our luck on 10th. 10th is a lot of matters, no? Huh? Tomorrow not possible. We can have Saturday also. I fix a lot of matters. Already 15 matters. Saturday already 15 matters. First I won't be there. Anyways, we can have it on. Let's have it on 17th. Although I may not be there, but somebody else will take it. Let's put it on 17th. List the matter on 17th to 2026 for admission.
Look, we have prepared a compilation as per, as last suggested, my lord. I have given the copy. Yes. Look, these are the copies. We have prepared subject wise and we have given the details of all the districts, my lord. These are all priority projects. The headings are, my lord, court building new, then residential new, then residential repairing and court building repairing.
Wood building priority person.
Court building new, court building repairing.
Installation of CCTV. Please have the social. The Borpeta doesn't have CCTV.
Which is Kokrajhar, my lord?
Borpeta district judiciary doesn't have CCTV.
Phase three. Phase three. Court building new.
Was that not a part of the building?
Borpeta.
Because it has been done recently, only 2 years back.
Additional CCTV.
What is this additional CCTV?
Installation of phase three. Additional CCTV. Yeah, page three, my lord, serial number 1, installation of additional CCTV camera in the new judicial court complex, block 1 at Borpeta.
Silchar also had a new building, no?
Silchar, yes.
What about the CCTV in Guwahati High Court?
Function.
It's gone. It is being done. Yes. Functioning.
Come to page 5.
Yes, ma'am.
It says building is new building.
Kasar.
Acha,
Yes,
isn't it?
yes.
So if you come to serial number 1, when a building is electrification, everything is done, then earthing is not done or what?
No, ma'am.
Without earthing electrification.
Probably it was left in the project, main project.
How can that be? Without earthing, there is an electrification.
Yes.
Huh? Then how a building can be given completion certificate? And what is this removal and reinstallation of solar panel in a new building?
Removal, reinstallation.
Why removal? Why reinstallation?
Changes.
এই হেৰিখন ওলাব, যোনখন বিষয়খন তাৰ পৰা।
বনাই আছে। বনাই আছে তো।
Yes,
But the
Mr.
third and fourth floor is, construction is going on still. Third and fourth floor. Acha.
But it is not say third floor and fourth floor. 7,60,000.
Look, here the problem is that everything, look, it's just a summary of the entire thing.
No, that, but if you gives this kind of summary, you will have questions.
No, no, definitely, my lord. Lordship will definitely have questions. It removal and reinstallation. Google হেৰিখন নাই?
সেইটো হয়, মানে construction will নাপায় without looking into the.
We can understand serial number 7 at page 6.
Yes, my lord.
Remove and reinstall solar panel from roof of present rented campus to newly constructed else.
Look, this serial number 2, if I have, so far as the instruction has come, I think new fund has come under eco project, is it? No, under?
No, fund has come, that is a
And
different.
pursuant to that fund, my lord, this solar panels earlier has been replaced by new.
No, no, it's not replaced. Removal and reinstallation. You are not
Exactly, Milord.
replacing it.
Earlier that was removed and replaced. Reinstallation,
What
reinstallation,
is the necessity of doing so? Must know.
correct.
You will put something here and tomorrow somebody will pay 7 lakhs or to shift it to that floor.
No, 74,000, my lord, it is.
Whatsoever.
Yes, my lord, correct.
Evaluation to state property.
Lord, my instruction is that all these projects are already approved by the building committee after, my lord, detailed deliberation into it.
Just for understanding.
Yes.
Suppose something is placed, hundreds of project proposals are coming from different districts placed in construction committee. Now, is there any material or anything is available before the construction committee that these are the budgetary provisions, we can only recommend this?
That is probably not. That
Or
is
is
probably
the
not in
budget,
place.
you see, there are many things. The state spends or allocates funds on the basis of a budget which is being prepared prior to 1 year. Means just for example, in the budget which is going to happen, which happened on 1st of February 2026, for the for the next year, financial year, starting from 1st of April 2026 to 31st of March 2027, the Union Finance Minister has given a budget that these are the things for which we are allocating budgets. So, is there anything being done earlier that you are coming up with proposals of the proposals which are being given? But are these things taken into note by the finance minister, of the state finance minister, at the time of preparation of the budget? If this being taken into note, then obviously a fresh one maybe the proposal may be given. But these certain things are of the year 2024. Now we'll be having the budget of the year 2026. So are these these are bases which are being given to the finance, these inputs are being given to the finance minister or the finance department of the government of Assam that we require these budgets for this year of 2024. These are proposals which have been given in 2025. Then only these budgets. Yes, the necessity for that, the High Court Administrative Committee will forward it. What is being seen out here that the budget is on lack of budget, these administrative approvals have not been granted. But are these at all placed before the finance department that we require these budgets for the future? It appears that what is being sought for, there is an allocation. Every department has an allocation at the time when the budget is being made.
Provided accordingly, the budget is sanctioned and they will utilize in the financial year.
Yes.
That's right.
So for each
This-
department,
This proposal must be.
So during
Yeah,
the
before
currency
the
of the
budget-
financial year, my lord, if anything is required, then supplementary budget is placed.
no, that is another thing. That is a supplementary budget is a budget which will be later on put
After 1st of April.
after the 1st of April, a supplementary budget. But initially, when that particular budget is being prepared, are these aspects being brought to the notice of the finance department so that because what is happening is It is at the,
This is the demand from High Court.
Yes.
What is here?
no, it is, what is happening is, it is for the finance department to take note of it. But in view of the judicial department not forwarding it to the finance department,
No, my lord, we have been forwarding it.
then
Before the-
who gives the administrative approval?
It is the judicial department.
So therefore, my question is, are you forwarding and then taking the inputs and not giving the payer?
They ask for the estimate, my lord, before placing the budget. And it is being provided from the judicial department on the basis of what is pending in the previous year, the proposals pending. So on that basis, the finance department is apprised that this much amount is necessary for sanction. It is on that basis the amount is granted, my lord. And whatever, because this keeps on continuing, it's a continuing process, my lord. The
No, no,
proposals keep on
the
coming.
various, Mr. Chakraborty, the demands which are being made will be continuous. There's no
Continu-
quarrel with that. The proposals will keep on coming. But the fact that for the judicial department to prove there are two aspects. One is the administrative approval for going ahead, and the second is the financial sanction. The financial sanction will be given by the finance department. Financial department can grant the financial department financial sanctions provided it is included in the budget, or there is a scope of putting it in the supplementary budget. Then only the financial sanction will be granted. But who gives the administrative department administrative approval is the judicial department. Now here is a case where the judicial department has not done it on the ground that the finance there is no budget. Now who is informing you there is no budget? Taking into account that these have been certain demands which have been made or the proposals have been given in the year 2023-24. So this is prior to 24, which is being given is much prior to the financial year 2025-26. So therefore, has these been placed before the budget? Finance department. Now, unless you proved that,
my lord,
because there has to be a preparation of a budgetary provision.
The demands are being made, but the
Look,
grants.
to make the demand, there must be some provisions. And to make the such provisions in budget, they must have an information that this is the requirement of High Court.
The requirement is being placed, my lord.
So you want to say that these are not allocated in budget itself?
My lord, the required amount is
give
not
the
always
Mr.
granted, my lord.
Huh?
Give the
Required amount is not granted.
No, it is a different thing. That means when you are submitting the proposals, so for submitting the proposal, there has to be an administrative approval from you. So what is happening is on the verbal discussion with the finance department, you are not putting the administrative approval. There has to be something, some relation,
My lord,
or are you placing it to the finance department and the finance department is saying no?
No, my lord, the finance, so far as the sanction, the administrative approval, my lord, the financial sanction is being granted by the administrative department only. The money is placed.
You want to say that we can grant an administrative approval only after financial sanction?
Yes.
Is it your proposal?
The final, yes, my lord, the budget is placed, my lord, with the department. And then on the basis of the availability of the budgetary amount, the
Question is, who will make budgetary provisions for the High Court? Say this is the construction projects proposed by High Court 1, 2, 3, 4. We need 100 crores in this financial year. These are the pending matters, these are priority. There must be some budgetary provision made in the budget.
Yes.
So if it is made, then finance will give you a financial sanction. If that is not there, they will say, I don't have any budgetary provision. So it is nothing but a futile exercise approving in the construction committee and sending it to you, and finance will say, where is the budgetary provision? So budgetary provision must be there.
And
So
therefore,
we'll have to give a proposal that this is our budget for this year or the next year, so make provisions. They may make whole, they may make half, that is a different aspect altogether, according to our understanding.
you see, I tell you why. This Article 202, I will give a constitution to him.
Give him. ঠিক আছে। Okay, fine.
Constitution আর copy নেই? আপুনি ন এই ডাকচতো কোৱা নাই চুফি গগৈ বুজাও
আমি যিখিনি available, সেইখিনি utilize কৰোঁ।
Yes, anybody has a constitution?
My lord.
Oh, yes, give it to me. C 201. Where a bill is reserved by the financial matters, 202. The governor shall, in respect of every financial year, cause to be laid before the house or the houses of the legislature of the state, a statement of the estimated receipts and the expenditure of the state for that year in this part referred to the annual financial statement. The estimates of the expenditure embodied in the annual financial statement shall show separately the sums required to meet the expenditure described by this constitution as expenditure charged upon the consolidated fund of the state. Just for example, the salaries of the judges, the salary of the registry, all these things will come within the ambit of the consolidated fund of the state. So this will be put in the budget. And the sums required to meet other expenditure proposals to be made from the consolidated fund of the state. Now, the state is bound to provide the infrastructure. For that, these are infrastructural projects which have been informed to you. Now, the question, therefore, as my learned brother has put it, have you intimated the finance department prior to preparation of the budget that these are the requirements which are required for the purpose of putting it in the annual financial accounts in the budget? If you don't put it, then they will always say that now we have to go for a supplementary budget.
We do so, my lord.
So if you are doing so, then the question is why it is being not put in the financial budget. You see, when you are putting all these things, just like we see out here many things from 2023, which has been said to be the priority. And this priority has been come up on the basis of a discussion being carried out by the registry along with you. So when this priority is being looked into in respect to matters, we are not concerned about 2025-26 at that now, because these are prior to that. But anything of the financial year 2023-24, 24-25, this must have been put in the budget. Now, if the budget is being not put, give us the reasons why. Because if you don't put it in the budget, yes, therefore, what is happening out here? You are saying the A is not being issued because of no budget. The budget will only happen if you put it.
I want to.
Just for example, we see our new High Court building to be constructed. It has been announced out here that initial budget will be around 500 crores and remaining will be another 1700 crores. This is what has been stated, or 1200 crores subsequently, which makes it around 1700, 1800 crores. Now, this 500 crores aspect, have you put it in the budget? Or are you going to put it in the supplementary budget? Or is it going to be put in there as a not being issued on the basis that there is no budget? Though it has been announced out there in all the programs that 500 crores have been announced, which we spent out here. So therefore, the question is, it has to be included in the budget. Just for example, earlier, for the purpose of that particular place to be taken up, an amount of rupees 450 crores was given, isn't it, Mr. Iya? Was put out there in the budget. That was being put. 450 crores, a budgetary provision is being prepared. Whether the state has the money for giving it at a later stage, it's a different thing. But there is a budgetary provisions being made. Where is the budgetary provision in respect to those proposals which have gone for those years? Have we looked into that? Otherwise, we put priority, we don't put priority, nothing is going to happen unless you put it in the budgetary provisions.
Make provision.
And has to be made provision that this is it. Now, if you have it, just for example, for this year, we have a budgetary provision of this. And additionally, for the purpose of repairs and all, there will be a further budgetary provision of this. Then in that regard, what will happen is the department or the High Court will know how much to spend where. The proposals will keep on coming. There is no end to it. When you are having an infrastructure, when you are having a court functioning out there, there will be, the proposals will keep on coming. Not only the proposals for the purpose of infrastructure, just for example, the proposals as regards the expenditure for stationery, everything will keep on coming. But as regards the proposal of the salary of the High Court judges, the proposal as regards the salary of the registry will always be there because it is already charged to the consolidated fund of the state. So therefore, if it is already there, so it will always be put it. Like which you have put it. Just for example, the salary of the judges in the consolidated fund of the state. And therefore, you are putting in the annual financial statement, you have to also include whatever it is there in 202B and say that these are the expenditures which are there, for that budgetary provisions are there. Maybe the finance minister or the finance department say, okay, we are not going to give you this budgetary provision for this year, we'll look into the subsequent year. That is out there. But where is the budgetary provision for that? It appears what is happening is what is being asked for, the government is saying whether budgetary provisions are specifically made for the judicial infrastructure. Is it there or not?
It is there, it is there.
How much it is there for the 2024-25?
Rightly stated, supposing in 2023 or 24, a particular in between some proposal is submitted, that was not granted. That should have been incorporated in the budget of 25 and 26 as a expenditure.
So therefore, it can only be done if there is an administrative approval being granted by you so that it can be put out there. Now, what is happening is the finance is saying that kindly don't grant the administrative approval. We don't have it. We are not asking you that immediately you have to do it. But unless you make the provision, how do you make the provision unless there is an administrative approval?
No, my lord, it's like that. So far, I have been, since my joining, I have been following. It is the budgetary provision that is available at the disposal of the department only. From there only, the administrative approval can be issued. That is the system that is being followed. The estimate is being
So
asked.
this will be there in the Assam Rules of Executive Business.
Yes.
Mr. Gogoi? This will be there in the Assam Rules of Executive Business. That the administrative approvals are given provided there is a budgetary provision. So therefore, it cannot be for the purpose of 2025-26.
DFPR rule has come, so it is there in the DFPR rules.
It says,
It says about how the money can be disbursed.
okay. So then how will the finance department know that this is a request? You just forward it.
That is done before preparation of the budget. The department is being asked, what is the amount you require for the grant of the administrative approvals? So on the basis of the report given by the judicial department, the finance department makes the provision in the budget. On the basis of that, it is available on the system. And when the particular proposal is being taken, it is seen that the money is available, so administrative approval is granted. It is a system-based thing which is put in place. It happens like that.
So therefore, the question is, when the proposal goes to the judicial department places the matter before the finance department.
No.
Goes to where?
The judicial department, once it is forwarded from the Honorable High Court, judicial department only confirms it from the budgetary provision.
No, we are asking
My lord.
that suppose this High Court repairs 100 crores for future project this financial year.
So that has to be,
Preparation of budget.
yes, my lord.
How High Court proposes or gives your finance department that this is our requirement for this financial year. Then only there will be budgetary provision.
Yes.
Then as per your thing, this is in the website that this amount is available. So
Available, so-
accordingly you
Yes,
will issue
ma'am.
administrative
Yes,
approval.
yes, my lord.
But how this finance department is let it known by registry that this is our requirement?
That is done, my
How?
lord.
How?
As we are, I mean, that is before the preparation of the budget only, they ask for the requirement and then only we submit it.
So in the budget, there would be obviously provision for the infrastructure.
There is provision.
So, no, so therefore, we understand, we are to understand
Yes, ma'am.
that the moment the state, the High Court provides the proposal, just for example, the proposal of the year 2023 or 24, is it required to be reiterated?
No.
So then how do you choose that 2023 proposal? The budget was there for 2023-24 or a particular proposal, just for example, the solar installation at Bukakhat. The budgetary proposal was made, the proposal was made in the year 2023 that we require this thing. Now, the budget, if not prepared for that, if that was not taken into consideration for preparation of the budget then, subsequently, and if you are not reiterating by them, then can you give an administrative approval later on in the year 2024 or 25 or 25-26? Because you don't have the budget for that. The budget has lapsed.
That has happened, that has, in fact, my lordship is very correct to point out. That has, there is some deviation that has been happening because that has been actually done on the basis of the ground realities, I mean, the requirement, because the judicial infrastructure, sometimes the requirement is immediate, my lord. So.
No, we are,
Not always,
no,
my lord.
Mr. Chakraborty, we are not on the question of immediacy as regards 2025-26. I'm saying about things of 2023-24,
My lord, because
24-25.
The budgetary amount that was granted then, it got exhausted because of this kind of deviations, immediacy because of the immediate requirements, it got exhausted and so the projects left out. I mean, it could not be sanctioned administrative approval, my lord.
Ideally,
Ideally, though, year was. Ideally, I mean, year wise, আমি করে দিতে পারি।
So in the budget, which is given, just for example,
My lord, if I may just submit,
yes,
ideally, my lord, it should have been exhausted. We should have actually exhausted the budget of 23 in the 23 itself. That should have been the ideal situation,
And-
my lord.
and
because
that
it
should,
was-
that should also be
Yes,
for those projects.
Yes,
You see,
yes,
when a finance minister makes a proposal before the legislative assembly, let's say we are giving 400 crores for the High Court for the in the judicial infrastructure. Okay, let us example. That is a statement which is being made by the finance minister on the floor of the legislative assembly. But if you see the budget, then in the budget it will be given in which other proposals these 400 crores are being made. Now the question is, if these are the proposals on which it is being made, are these administrative approvals immediately thereupon being granted? Or is it being deviated? If that is being deviated, that is the reason why we don't say, because the rejection of all this priority is on the basis that the AA is not being granted. Just for example, that day, the union minister said that we have granted 2,07,000 crores for the purpose of having high-speed rails, specific from this sector to this sector, this sector to this sector, this sector to this sector. These are the new 7 sectors. So therefore, when any of these sectors are brought in, because the budgetary provisions is being made, it will be then given only in these sectors. But for the purpose of bringing it from Siliguri to Guwahati is not there. And they cannot deviate it from there, from the budget, and bring it out here. Unless there is a supplementary budget for that. So these, are you therefore giving it on the basis of the proposals? Or just, oh, look here, the High Court is there and the year is there, we give it 1,000 crores for this year. And because of that, this problem is being faced. Yes, finance.
This area budget estimates now that has been placed in 4 volumes. For that probably to be work out that the priority is now out of this because it's a huge amount go by these 4 banks. So if they want to incorporate probably whether there is time or not for this 26-27 budget.
No, they have to be brought to the notice of the finance minister.
Yes.
If it is
But
not
in
being
that
brought,
case,
it is,
not to
you are
remember.
doing it on the basis that whatever, what appears from what you are saying is, the government is providing a particular budget in this particular, for the judicial department. And out of that, you see on emergency, this is required, we give him 50 lakhs. This, we give him so and so. But not taking into consideration the proposals which are being made. And this is the reason why we are having these problems. And
That's
this
correct.
is not how a government functions. I have to tell you, the budget is not being done. This is not as for the constitution. The proposal has to be, it has to be proposal specific. If there is anything else, there will be a supplementary budget.
In fact, during the pendency of this petition, there are 21 numbers of administrative approvals were approved by the finance for repairing and renovation of toilets. So it was done in between. The amount has been sanctioned and work is going on. So like that, in some cases will have to be provided in between the.
No, there has to be then a supplementary budget for that.
Yeah, that's right.
There has to be a supplementary budget, and more particularly when you give a budget, there has to be also cushion. It cannot be tight in a sense because there might be certain exigency. A fire takes place in one of the buildings.
Port buildings, new priority projects, serial number 1, increasing the solar power capacity. It will not be there in the main project. It has been, now it has come up, so proposal has been submitted and provided there is budget available. So,
Now, what is being happening is this solar power project, if there is much of insistence, just for example, the court puts an insistence, or on the administrative side, so what will the LR do? Okay, we sanction this and thereby taking away from somewhere else.
adjusting.
So this is how it is being done
This
on the
is-
basis that, but the proposal has to go. These have to be brought within that scope or notice of the finance minister who prepares the budget that this is the requirement. And yet it has been shown to be priority. Although certain things still we don't consider it to be priority. Priority means where it is emergent, where it is required. Just for example, a case of transformer. Without a transformer, it is not working. These are priority, which
These are
needs
basically
at
pending
utmost.
actually. These are basically pending,
No,
list of
we are
pending.
time and again saying we are not interested with pendency, we are interested with priorities.
Priority.
Say suppose phase 2, serial number 3, this can be a priority.
And Mr. Bigugo, as well as Mr. Chakraborty, please understand. It is a constitutional duty on the part of the state to provide the infrastructure for having a judicial courts as well as the high court. There's no quarrel with that. It's a constitutional duty. Under such circumstances, things which is of prior nature, priority, has to be done. Now, there are many expenses which are being made. I won't say anything on that, but here also, equally, these certain prior things, priority where it is required, has to be given priority. It cannot be that the High Court or the infrastructure out here will be keeping on begging out here for money. No, it is your duty. And you see, it is another thing which we have seriously considered. The problem which we are also facing out here is there are demands being, quotations being made, or the provisions which have been made by the PWD is exorbitant. Something has to be worked out. Certain aspects, it's exorbitant. So therefore, if you don't do something to that effect, either provide creation of a post out here in the area of a PWD out here, some engineer, like we have a doctor, have a post out here for the PWD, an engineer, maybe on a contractual basis, so that things can work out in this manner. Who can may have a oversee of all the judicial infrastructure. We as judges are not competent. Neither the judicial officers who are in the rank of the register or the register PMP, they are not competent for that. It will be an engineer who will be doing it. Now, the problem which we face is many of the constructions are not done properly. Maybe for some connivance between the PWD and the contractor, we may not know. But these happen. This is actually happening. Let me give you an example of the one is in Gopur. But there's I have seen it with my own eyes. A construction in Tejpur, a DSLSA building being constructed. It was constructed in the year 2019. It started in the year 2015. Yet to be completed. Okay. The construction is G+4. Okay. Now, the heritage building which is there, that building under no circumstances can be repaired or done anything with that or renovated, taking into account that it is made out of Ereka walls and all. So what is required to be done now is that there's a dearth of space. So you can very well construct another 3 floors over the DLSA building. It is there, provision is there. I asked the authorities out there to make a structural inquiry as to whether it can be done. It is yet to be completed. He said that the construction was started in 2015, and now it would not advisable to do it for G+4, although not yet completed. Meaning thereby, the construction has not been made in that manner. It is, after all, a project for the people. Gone are those days where the contractors could do anything. But nowadays, everything, stringent measures are being put out there. So therefore, these things needs to be looked into. No, they are the committee. There are committees. You see, there are committees of the district. The infrastructure committee is there, headed by the district judge, along with an executive engineer. It is there. But this is the problem which is seen. So therefore, the problem is, and you see, the district judge today is there, tomorrow is transferred out. He's not bothered what has happened out there. But at the end of the day, this is a judicial infrastructure. If you go to, just for example, in Tejpur Court, I tell you, around 20 years back or 17 years back, it was a beautiful compound with ajar trees and all. There was nothing out there. It was a beautiful compound. Now what has happened out there? Everywhere it is a G+1, ground floor is being constructed with provision of G+2. Piling has been done. No piling is being done. With G+2, you don't need a piling, which is on a pillar. But if you want to make a G+4, you can't. Now, that is a huge area which was there, but it has been wasted. Now, the question is, it is very easy to make a construction, but nobody wants to make it G+4 or G+4. Above that, nobody wants, because most of the things happens in this manner. A serious consideration or introspection has to be made on this aspect.
Mr. Gogoi, can you give us the data of last 5 years, the provision in the budget for judicial infrastructure?
I can,
Whether it is increasing, what is the trend and what from?
I can do so. 2025-26. From 2020.
Last 5 years.
And in the meantime, you place these immediately before the budgetary committee.
Yes, my lord.
And see, there are certain,
Yes.
you come to page 2. These are, I do not think subject to what my brother says. This is required. I will not say this is not required, but I don't think
Well,
it's
my-
the priority in a situation where there is no
my-
budgetary provision. Come to serial 4 and 5.
My prayer would be before your lordships that we are making this column priority. But all the proposals which were sent,
Give us
all are,
justification for priority in a column. Why it's so priority, upgradation of modification of video conference or district judge. Already there, you need an upgradation.
Milord, if
And
we
what we
don't,
see
if we
is-
don't upgrade, Milord, then now it's
No,
all
I am
upgradation.
saying this is very important, but is it a
No,
priority?
that is what I'm saying, Milord. Lordship, we are making,
Priority within this budgetary provision.
Milord, in my humble submission for judicial infrastructure, anything which has been sent from the judiciary to the state are all priority. There cannot be a subhead of, Milord, a new priority, old priority, or a high priority, lower priority, Milord. All are to be because it's the
Then you have
constitutional
to,
mandate.
then you
Milord.
have to ascertain while sending these proposals. I'll give
No,
you
no,
an.
subject
give
to
you-
correction, my lord,
I'll
that
give
is,
you, I'll give you an example.
Milord, that is my
I'm giving
understanding.
you an example.
Yes, my lord.
Soraidev, a new building is coming. Okay? Mr. Borua knows a small Assam type house behind the new present building is to be demolished for construction.
And
Including the present court building is to be demolished for construction, and this it is being proposed that it will be shifted to the Deputy Commissioner's office, and you are giving proposals for construction of Aslas in that Assam type house. Please tell us. We must also be cautious.
Milord,
Your
as
statement
last-
is correct that whatever High Court says is priority, but High Court should also be conscious of their demands and within the budgetary provisions.
No, so far as budget is concerned, from the discussions, what I have learned is that, my lord, finance department or judicial department asks for requisitions, what is the requirement, then it is sent and accordingly budget is earmarked. That is fine, my lord, that is the normal thing. But since this
No,
proposal has
Mr.
come,
Das, that is not what is happening.
I understand, my lord, that is not happening.
That is, no, therefore, I think you will appreciate that this bench knows the meaning of the word priority.
Definitely. my lord, that-
When there are 482 proposals being submitted,
Correct.
and we said that give us a data on which is priority, means it requires immediacy.
This has happened because it's a stopgate.
There's
management
no
type thing.
quarrel,
Just
Mr.
management
Das,
type.
Mr. Das, there is no, Mr. Das, there is no quarrel with the fact that whatever the High Court requests
Correct, my lord.
or proposes, they should provide,
Correct.
with a caveat that the request also should be reasonable. Okay, that has to be also there.
Yes.
We also cannot turn a blind eye to the fact that the request also has to be very reasonable. You don't make a request just for the sake of it. Let me give you an example. I'll give you an example. A proposal is being given. As of now, Nahargotia is not a judicial district. Okay? A proposal is now being floated for providing a district court building having 9 courts when we are having 3 judges with a budget of 88 crores. And it is this budget has been, this proposal has been emphasized not once but twice. Then we had to turn it down on the administrative side that what makes it that this is to be done in this manner?
Correct.
What is the urgency? It's a different thing. We have looked into it. But if this proposal has been accepted and sent out there, wait,
Yes, yes, yes. Understand.
the government may not have a problem with that because it's a 90-10.
Correct.
But is it justified?
Not at all. That's why, my lord.
If it is justified, no,
Sir, there-
but let me give you the example of where it has happened. Bukakhat, it is still an HGM court. A court which has 2 judges, you have 9 courtrooms as of now. Was it justified? No. But it has gone, they have provided, matter has happened. So therefore, things, priority, yes, request may be made, but there has to have a priority when we are asking is where we require a judicial intervention. Otherwise, on the administrative side, the High Court will take it up. High Court will take it up as regards the administrative side with them. We have 5 judges out there who will take it up, take care of it. But for judicial intervention, we require priority. That is the word of priority which my learned brother has said.
And see, this, I am adding to this
Perhaps
Bukakhat.
not-
I am adding to this Bukakhat. Now, you cannot argue because everything is echoed. You cannot speak this kind of a huge building for 2 judges.
Some filtration process, my lord, perhaps in
So
our
therefore,
part
this
also.
part- This judicial side is, as my brother has said, not for discussing or doing all those. We are not sitting as an infrastructure committee.
No,
We are
correct, my
taking
lord.
it a judicial side, so therefore we have emphasized the
larger
priorities where
issue.
judicial orders need to be passed.
This priority
Where
thing
it
has
is
come.
required to be streamlined. Just for example, budget being provided of 1,000 crores. But
That doesn't
budget
mean-
is not project specific. Resultantly, there is deviation. These are the things which requires to be done in order that, because you see, one has to appreciate one thing. The court is independent of the executive and the legislature.
Exactly.
We have a totally different course of action. How we act, who are our employees, how
It's our business.
these employees are to be appointed, but following the mandate of Article 14 and 16. What should be their salary? All will depend upon the court,
Correct.
not on what the executive thinks. They are not the masters to that effect.
And they have also a bounden duty to provide infrastructure, judicial infrastructure. This
Yes,
is
yes.
not for judges or lawyers, this is for the citizens.
This is for the
So
people.
they have a constitutional liability and responsibility to duty.
That's
to
why,
do
my
this.
lord,
So therefore,
made that
therefore,
submission.
see, we cannot ignore, we cannot impose that this is our project, please, we cannot issue a mandamus, just make this
No, 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 no.
10,000 crores for us. But that must be also be reasonable in not doing so. Therefore, we are asking what is your budgetary provisions?
correct.
Let us see how they are providing.
Allocating the money.
We will fix it on for 7th of March. It's a Saturday. We'll have it on 2nd of. And then first we will ask you to provide us for the last 5 years how the budget has been provided, how much budget allocations have been made for judiciary and the infrastructure, and as to whether it is project specific. And secondly, and if so, how much is the cushion given? There has to be some cushion. And in the meantime, you immediately provide to the finance department the requirement for the next budget immediately. We'll take it up. How they do it or not, how it is to be done, it will be
With
looked.
all the outstanding, I mean.
Whatever may be.
Whatever.
more particularly these priorities. How much they let them consider. You see, you being a judicial officer also may not have the expertise. They may have an expertise as to choose which may be relevant, which needs more priority, and thereby they will put in. Let them do it, whatever may be. We'll take it up why it was not there, whether supplementary budget should be made or not. We'll take it up on that aspect. But you need to immediately place it before them and let the finance department in consultation with the finance minister look into that aspect.
Lord,
That is
one
the second
thought,
thing.
my lord. Just one thought, my lord, that has come. Lordship says, give example of that, my lord, improper construction of one particular building. My lord, just I have in my mind, if some, my lord, mechanism can be developed in the High Court for quality control, because for the district, in the district, the committee is headed by district judge and executive engineer of the PWD. So
DC also is there.
DC, fine, my lord, DC, but even after that, this construction had happened, then where is the quality control? Lordship will have it, my lord.
Let us not digress so much, but there is another very important issue apart from
Fine,
that.
fine.
Not go to this.
Yeah, not.
No, just
No, that is one of the examples.
that example, my lord, let me question, that's why, Fine,
Very well.
fine.
Good,
No issue.
Mr. Das had thought about it. Another very important what is happening is this. In view of the judgment in the case of Rajiv Kolita, what is happening is there's a specific direction upon the state to provide not only finance for the purpose of infrastructure of the toilets, but also for maintenance. Now, the problem which is being faced by the what you call the High Court, not the High Court, the entire judiciary as such, you have put a financial cap of a particular amount. The particular financial cap is around 2 lakhs or something. 2 lakhs. On the other hand, the total for the entire judicial department, for the entire judiciary of it comes to around 1.35 crores for maintenance. Now they are not in a position to make payments to the Sulabh and all. Wouldn't that be an infraction to the directions passed by the Supreme Court?
Cap has to be removed.
Because you have the cap. Now the problem is, for the finance department or all these other departments, they don't have a problem of that, they provide it. But as regards these, for maintenance of the toilets, as of now, I don't think the High Court has the money for payment to the Sulabh out here for the Guwahati High Court. Understood, but why? What is this? You have to provide the funds. So if you are putting a cap to that effect, yes, you may very well ask for utilization certificate. Ask for the utilization certificate, but in respect to these expenditures for maintenance, yes, for maintenance you have already said. You may first take up initial budget out there and look into it, what are the things what they are having it. And thereupon, you cannot put a financial cap on that. What is the salary? Yes, if the salary is fixed at 7,000 for each person out there in the Sulabh, yes, they are appointing 10 persons out there, they should have 10. If it is more than 10, then obviously they will have to ask the sanction from you. That's all. But as of now, what is functioning, how it is being functioned, this has to be brought in. By putting a cap, the problem is that the maintenance is in a very bad shape.
For enhancement of that cap, my lord, proposal from the judiciary has, registry has already been submitted to the judicial department. Is there reflected in the court's order?
No, now where is that
Yes,
project?
one
Where
is-
is that
yes,
pending?
my lord,
Lying with the finance department. Manoj.
So therefore, why the
I will
finance
have-
department should hold to this?
So the registry is holding top.
No, understood. Let it be pending before that. But then we should therefore place it before the Supreme Court in the matter which is still pending, that this is what is being done by the finance department and proposal is not being provided. Let the chief secretary answer to this. Or we ask the chief secretary to appear before this court next week. Because the direction initially which was being passed as regards the continuation of this providing the maintenance is absolutely within the state. The state is directed to provide. And because of the financial cap, this is in a position. There's a clear mandamus to that effect. In fact, I have put it in my order. Our order, we have put it. Where? In view of this, kindly see this direction. Where ensure that they stocked so and so, have a transparent so and so provided so and so. The state government UTs shall allocate sufficient funds for construction, maintenance and cleanliness of the toilet facilities within the court premises, which shall be periodically reviewed in consultation with the committee constituted by the high courts. So under such circumstances, and then a status report shall be filed by all high courts every 4 months.
Mr. Das, you being a High Court standing counsel, you file a status report.
So this is what is happening.
Look, this is the capping, we have written, my lord.
Yeah?
No, we know that.
Yes.
Keep it for timing.
Yes. It can, it should be intimated, I think, my lord.
I think this should be placed, let the chief secretary, and we have put it to the notice of the chief secretary, and the chief secretary has not done it, so obviously we'll take it up with the chief. We'll say that in spite of that,
Subsequent.
Yes.
orders have not been complied.
Then I've got the instruction, I can place it.
Place it.
Yes, that order is there, I sought for the instruction. Probably, my lord, that proposal is not.
No, you cannot have a cap on the existing strength. Existing maintenance which is being going on. You cannot have a cap on that. Because of that, they are not being able to provide the maintenance. I would have said, if they want an additional, yes, you may very well look into that aspect. But in view of the clear mandamus being passed by the Supreme Court on this aspect, because of this financial cap, this problem cannot have.
For that, my lord, the proposal will have to be mooted, my lord. How will the finance department know, my lord? what
No,
is
it
the
was
problem
moved.
going on?
It was
My lord,
18 November
Yes, that's right.
2025.
And that I instruction. has
And
not
where
been
it's been done.
Yes, what is your instruction in this regard?
Well, the finance is taking up this matter, but I have, they have not
It
yet
has
cleared
gone
the,
through you.
I have also talked
Yes,
to
this
the,
one, I have already.
to the Commissioner and Secretary Finance.
On my lord, parts, my lord, whenever it is fixed, I will place the status quo. On the next day, I will place the status quo. I will convey today itself about this particular. But some.
No, for 7th March is for the other one. For this toilet is next
No, in fact, the
Thursday.
last payment that has been made is because.
Next
of the
Thursday
high
is the
intervention.
last for this toilet business. Well, because this toilet cap has to be removed, nothing is this. Okay, we'll on 12th, we want that this cap to be removed for this existing, whatever word you may put it, but for existing expenditure, don't put this thing, cap. There cannot be a cap on the financial sanction. And how much is the expenditure? Do you have any details or you are just telling me? I have to pass it in the order, na? Anyways, we will look into this again on 12th.
Just keep it in the report. For engaging cleanliness worker in the good complex or some. No. Modi এখন করছো ঠিক আছে
So this amount can be used, Mr. If from this instruction it appears. No, whatever may be, instructions, this can be used now. 1 crore 20.
There is a budget provision of 121.01 lakhs under the above head of account so and so, and yielded department has incurred expenditure of so and so. Health department could encourage them.
So therefore, you can sanction this amount of 120 for the cleanliness.
Incur required expenditure. It is already available, balance amount is there, madam. If it is unutilized, by 31st March, madam, it will less.
We have submitted a supplementary proposal.
Presently, madam, there is a finance.
Capping, when there is capping,
No, the capping, they will remove it from all proper increasing. It's a pending, this 123 only.
One FS is pending.
So this, they can use it.
Hello, one FS is pending presently, one FS is pending. Financial sanction granted by the Honorable High Court is pending with the Finance Department.
Regarding.
That has
capping
been
part,
kept
madam,
hold.
Roxy will fix it next week. It's not inconvenient, madam, on that part for a short time.
No, no, this capping part, we will have it next week only. This 123, if this, okay, Monday at 4. Monday at 4. Huh? I'll pass the order. Only for this purpose. The other matter will go on 7th. I'll pass the order to the effect. For that, for him to provide for the last 5 years and decease.
Yes.
Let us now hear our Advocate General from Nagaland. What is the progress?
This can be taken up on 10th. No. I think it's listed for 10th also. We can hear it later. Our matter is also connected with the High Court building. only.
Oh, yes.
That is why I thought I was here in the morning. But whenever the date is fixed next, if required, we will be present.
Mr. Advocate General, you are here on 10th?
Not very clear.
Okay, okay. No, you just say that on 10th,
We'll make a note of,
okay.
we will look at it.
Okay, we'll pass the order, we'll fix it on that. Any good news from Kohima?
We are reaching the goal slowly with small pin tricks here and there. Reach it.
Furnitures are done, na?
Pardon?
Furnitures?
In fact, that is with the finance that's being released shortly.
Okay. So you, the contract has been granted?
Yeah, we have given it to the finance. They are
Okay.
dealing with the contract.
Okay.
Once that is done, I think
And the interiors otherwise is over?
little bit of work with.
Or is it work? I may be visiting on the last 2 weeks of February.
Oh, I'll keep it.
Last 2 weeks, if the chief puts my roster there,
We'll be there at.
we'll have it on 10th then.